he has directed Lordship see a movement, memo, and the next question. The next page, Lordship may see that 1 lakh deposit, 2 class 2 officer will be surety. In the case of 110, he never involved in any case, in any manner.
Take it tomorrow.
No, my lord, can it be after lunch? Well, last 13 days he in custody, his mother, sir.
Now, what are the offences?
Only 110. He's arrested 110. SDM has passed the order. 1 lakh. These are class 2 officer have it. After lunch?
Take it. My lord.
After lunch, ମୁଁ number ଅଧଘଣ୍ଟେ ଦଉଛି sir ଟିକେ after lunch. ନାଇଁ ମୁଁ ଦଉଛି copy ଦେଇ ଦେଇଛି. Let them take it. After lunch.
110. See the surety.
नहीं after lunch any time or 3 PM or 4 PM. ମୁଁ ଦେଇଦେବି ଆଜ୍ଞା ଅଧଘଣ୍ଟେ ଭିତରେ କାହିଁକି ଆପଣ
End of the board you get
yes
number.
yes
End of the
my
board.
lord
After 2 o'clock you tell me
yes
that it is numbered.
Yes.
Then I'll list.
No, number I'll give you in half an hour, but I'll enlighten the matter.
Subject to number, list it.
Hon'Ble.
Yes.
Lordship, one CRLMC, 1 to
In the
3.
meanwhile, my learned friend should cooperate us.
He's always cooperating. Don't
Yes,
worry.
that's why I'm requesting you once.
Always.
Lordship, CRLMC 1 to 3 4. Lordship had on last Thursday and reached the Lordship director to file written note. That is release of
Yes. That
release of
72-51.
Yes, and 63 confiscation proceeding.
You remember that, na? He argued, I dictated the order, there was a difference between.
My lord, I given the judgment relating to NDPS, my lord.
Very nice. Keep it with that file. Huh? Keep it. Half part of it, take it out and leave it out. Thank you very much.
My
Thank you very much.
My Lordship, hearing matter.
I'll take you as an MAC in this matter.
my pleasure, my lord.
My lord, one hearing this matter, my lord. Today is fixed for the hearing, my lord, but unfortunately not come. It was date fixed by the Honorable Justice S.K. Sahu, my lord. My respectful submission, my lord, you want to fix up date after vacation. Lordship picked up date, my lord. Any date, Lordship fix up. At least 10 minutes will take up, my lord.
Yes. No.
Vigilance matter, Lordships.
Madam, I need pardon to mention.
Hmm.
With due apology before mentioning, first I surrendered before me, don't misunderstand me. I'm barely Hazur Mahapa kitchen. In 2 matters, I have faced problem. In 1 matter, my lord recalled on 8/5/2024. My lord had at 2 PM, I have to beg apology. My lord has told me that matter be adjourned, already adjourned to Monday. Monday means 13/5/2024. But in the computer, due to overloaded, my lord is overloaded. I know. So firstly, I surrendered before mentioning, so that's why. But in the net, it has been uploaded 17th. I leave
17th.
I pray, my lord.
So 17th it will come out.
My lord,
2 days after.
if possible, tomorrow, my lord.
See,
Fresh addition, 1 minute will take.
today there are 150
My
matters.
lord, I concede with my lord. If possible, with
What is the big urgency? Can't you wait till 17th?
I leave it to my lord. Managing.
I think let it be 17th. It will be 17th. At 17th, in the first hour I'll take. Mention it. I'll take it the first item. Because the board is so heavy.
I understood.
Once I start entertaining the memos, immediate memos, the system is collapsed.
But it was in the list. My lord has put 13th. But
Take the number. If there is a scope, then prepone. Otherwise, let it be 17th.
if my lord will permit, there are 2 ways.
Yes.
My lord knows better than
Yes,
me.
yes,
On so moto, my lord can bring it, or I will file a I leave it to my
Let
lord.
it be 17. I'll dispose that day. Morning first item yours.
Another problem, my lord. My lord is overburdened. It is not possible to see all the files.
Right.
My lord may recollect 28 persons NBW was issued. My lord has told that the immediately type it out. But in the copy, it has not been written by the stenographer, that urgent copy. That's why I could not get the copy. Madam has taken the copy.
Upload it.
No, upload copy, the police not on.
What do you want now?
No, but file has gone. But due to
See, there also you also try to appreciate. There are
but the state, when my lord told that the but the stenographer, the duty of the stenographer to type it urgent copy.
I know, but sometimes happens, because of
Pardon, my lord. My lord, fresh matter, my lord. CRLMC.
May I be pardon, your lordship? CRLMC 2246 of 2022, your lordship. May can.
But that would be a complaint. If I see something, it should do. Be careful. Be careful. Okay.
In 3 courts I have on that day, but other 2 cases there was urgent copy, senior student.
I told them.
But I'm a part, yeah, even if my clerk approached me, but the court master told that there is no.
All right,
nothing.
all of us have to work together. You
I
may
think-
commit some mistake, they may commit some mistake, I may.
ମୁଁ ଆଜ୍ଞା
But
ଗୋଟେ ଦିନ
it's a teamwork. So
ଗୋଟେ ଦିନ ଆଜ୍ଞା 5ଟା କେସରେ 4ଟା ମିସ୍ କେସ୍ ଫାଇଲ କଲି ମୋଡିଫିକେସନ ସବୁ ଗୋଟେ ନମ୍ବର ପଡିଯାଇଛି
that happens what.
ଆଜ୍ଞା ଏ ମେମୋଟା ଖାଲି ଦେଇଦଉଛି ଲିଭିଟ ଯଦି ପସିବଲ ହବ ରିଫୋନ
Yes.
କରିବେ ଆଜ୍ଞା
Pardon to mention, my
May I be
Belgium.
pardon?
Bail jump you give it. Yes.
May I be pardon, Your Lordship? May I be
Yes, madam.
Your Lordship, CRLNC 2246 of 2022, Your Lordship, the cognizance order is under challenge. Your Lordship has specifically adjourned it to 20 August. Your
Keep
Lordship,
the memo, we'll see.
Your Lordship, a shorter date.
We'll see. Cognizance is not so important, but still.
Your Lordship,
Give
the
it because
petition,
you have mentioned that we'll take care of that.
Lordship is under provisional pension, some kind of difficulty.
Another memo,
Okay.
modification of order, my lord.
What is this?
In that,
Typo?
no, my lord, in that, my lord, 3 accused persons are present. In order, my lord, reflected that 4 persons present. Dispose of each case.
Pardon to mention, Your Lordship, CLMC 4248, 4249, it was on list last week before Your Lordship. A 20% interim order has been ordered against the accused in respect of 24 lakhs amount, but the accused has managed to obtain a stay from this honorable court. We have filed for a vacation of stay. If the matter could be taken up any day this week. at your-
20% direction is already there.
already there, Your Lordship. But but it has been stayed by this honorable court. Therefore, we have filed for a vacation of stay.
Give the memo.
Much obliged.
Yes.
Any mention, page 1, item 1 to 9. Page 2, item 10 to 25.
11, my lord, infectious, my lord, not fresh.
Not fresh.
11. CLMC for 6, for 9.
11. Yes.
Item 16, Your Lordship, I pray for an adjournment.
Adjournment 16.
16, yes,
Yes.
obliged.
Page 3, item 26 to 40.
Item 35, my lord. And you taken after that. Yes, 45 adjournment. 35. Okay. What?
My lord, item number 30, 31 and 32 after vacation. 31, 32.
Respected?
30, 31.
Yes.
Page 4, item 41 to 56.
41 and 42 tag instruction. After 6. 41, 42.
Page 5, 57 to 69. Page 6, item 70 to 82. Page 7,
Pardon my lordship. Item number 4.
Item?
Item number 4.
Wait.
Okay.
We follow phase wise we are doing it. Wait.
page 7, item 83 to 92. Page 8, item 93 to 101. Page 9, item 102 to 113.
123 minutes. Compromise matter may be taken up.
108.
Today? 2 p.m. Okay, no problem. 12 o'clock if you can drink, no problem.
123.
Whenever. Yes.
108, 108, my lord. The defense has been removed, my lord. May I pray for the witness, my lord?
Don't fix the date.
Petition, the memo has been added.
Whatever you want adjournment, you tell me. Otherwise, let it be there.
Defense, my lord, is removed. My predicament is that the Senate Council is against, he is supposed to appear on witness.
Adjourn it.
But the matter is, memo is allowed as this.
But that's right, but Wednesday I am not sure. Because
Let
see,
it be in the list.
you can't choose the date. That's the problem is, see, hundreds and hundreds of matters. You can't choose the date. We will see how can we adjust it.
My predicament is that.
21st. 21st.
My lord, the last trial court date is supposed to be 18.
Then he do it today.
The defect has been removed. The earlier memo was.
Whatever problem, do it today or let it be adjourned.
The senior council supposed to appearance 15 minutes.
You, sir, I'll tell you, don't fix the date according to your convenience. You see the convenience of many people. Hundreds of people are there, including the court. You have to accommodate all of us.
I have big apology for that inconvenience.
We'll see what can be done. Next.
Item 114 to 121. Page 11, item 122 to 128. Page 12, item 129 to 137. Page 13, item 138 to 147.
143, my lord. Today I am for some personal difficulties. I pray for tomorrow, day after tomorrow.
You simply ask for adjournment, we can give you. But don't fix a date of your own, because we have to.
I know that, I know that.
The problem is in this weekend, it's not possible. Give a date.
There.
Best possible date. Yes.
Revision.
143.
Revision matter.
Revision.
No, revision, 48 matter, CRMs. CRMs,
144.
43.
43.
43.
Revision, why don't you?
No, revision, no.
Where revision?
48 matter, my lord.
Yes.
I pray for tomorrow, day after tomorrow. Year also.
Tomorrow, not at all possible. Don't
Oh,
talk.
day after tomorrow, I pray.
We'll see.
Day after
Not,
tomorrow.
may not be possible.
Item 10.
One see. The problem is today you occupy the list. You, in place of your matter, some other matter would have been accommodated. Once it is listed for any reason you do it, one matter, two matter, how does it make it? Why can't you do it today?
I pray one thing, my lord. It will be taken up at 1 p.m.
That today we
Yes,
let
yes.
it. No problem.
Huh.
You are,
After lunch, I will be absent.
yes, no problem.
1 p.m. my lord.
No problem. Yes.
Madam, pardon to mention item 10, my lord.
Yes.
I pray for after vacation.
10.
Item 10.
Page 14, what? Item 148 and 149.
10 he gila.
May I please?
Yes.
Item number 4, kindly.
4 will come within 4 seconds. Wait. Give.
I mean,
Yes.
pardon your lordship, was for between the compromise, your lordship.
Yes. Item 1.
Item 1.
Item 1.
Item 1, paper passover, one passover.
No password.
One pass, short passover, man. Short passover.
Sort of after item
My,
10.
my senior on the way, my lord. Just
Because today, see,
Yes, yes,
150
yes.
matters. I can't pass over.
Item
one
two.
short passover.
Item 2.
Yes.
Yeah, status report was called for before that has been called for in earlier order, lordship. Here the petition is a advocate clerk, lordship. And we do let it issued against him, showing abscond in the charge sheet. And he is not named in the FIR, but in the later stage in course of investigation, he has been alleged and accused on the allegation of issuance of fake residential
Yes,
certificates.
My lord, what happened in this case, my lord? Charge sheet submitted showing him as absconder, my lord.
I pray.
Thereafter, he is absconded since then, my lord. And wherever is not known.
Why don't you appear here?
I
And
may be-
co-working persons matters split of case split of pregnancy co-working persons.
ସେ ରିପୋର୍ଟ ଟା
And
ଆଉଥରେ
trial
ସେଇଥିପାଇଁ
conduct-
ମଗା ହେଇଥିଲା କୋଇ କୁଚର କଣ ହେଇଛି ବୋଲି ରିପୋର୍ଟ ଟା ମାଗି
Is there any NDPS? I'll cancel it. Go on.
हाँ, से
ରିଲିଜନ ବେଲା ଗୋଟେ ଆଡଭୋକେଟ କୋର୍ଟ
That's right, but how can I release in 4
जानी से कौन हो बोले से पिक्चर को
What is the offense?
366 lordship.
Oh,
no my
No,
lord.
lordship. Offense lordship,
My lord, he put some for signature my lord and a
466, 467, 468, 434.
how many accused persons are there?
There are all total lordship a class, the accused persons are numbering in the FIR. That is a lordship 2. That is in the name of Tapan Kumar Giri and Surjakanta Behra. This is not the present petitioner lordship. So Tapan Kumar Giri and so far Surjakanta Behra, a report has been called for in the earlier occasion. What stage so far their trial is concerned, whether they are on bail or not.
they are my lord facing trial my lord. They are first split up.
They are split
So for
up.
these
And so
petition my
far
lord,
this petition against
What is the stage there?
my lord, their trial is going on my lord. So far we have got the instruction my lord.
Where is the NBW order?
The NBW lordship, this is the order 4/12/2017 lordship.
You tell me, I'll protect you till whatever time you want. Go ahead.
Go on, sir.
Right. The petitioner has challenged the what have you challenged? Entire petitioner in his petition is seeking quashing of the entire criminal prosecution initiated against him, pertaining to CT case number for use of prayer. So,
Your old case, 2015 or facilitated for the trial.
Mr. Ragada appears for the state and submits that there were how many accused?
It is your lordship altogether 3 accused persons. I am not charge sheeted accused. I am not a FIR.
He has been charge sheeted.
Charge sheeted.
Charge sheeted 3.
Charge sheeted.
There are 3 accused in the present case. Out of them, the present petitioner is absconding. Insofar as the other 2 accused persons are concerned, the trial is progressing.
Charge sheet में मतलब एक number आसामी को.
In the meantime, on 4/12/2017, नहीं, NBW issued on
17 year lordship.
Huh?
17 I given the circuit court.
17?
The top of the order data like I told you.
कोर्ट में था किसमें? We
4/12/2017 lordship.
yes. In the meantime, on 4/12/2017, the court of JMHC Galisper in CT case number 546 of 2015 have issued NBW against the petitioner. The said NBW has not yet been executed. It has not been executed. Mr. Janardhan constantly submits that his client would be appearing before the court below on or before 1.
छुट्टी आ गया पड़ती 50
तो जब भी कौन था? June 30th
आएगा
30th June 30th June also and every remedy under law. Under law. Subject to the petitioner appearing before the court, appearing oblique surrendering. There was some problem appearing surrendering before the court below on or before 30th June also. The execution of NBW issued against the petitioner by order dated 4/12/2017 by JMFC Galisper in CT case number 546 of 2015 is state. In the meantime, no coercive action shall be taken against the petitioner. This much protection I have given you.
One line you see year-old case, you see much water has been flowed by that time. The court will consider the verification. Then we take it.
That court will also see how much water is flown.
You can also whether the
You allowed the water to flow for such a time.
He knows very well the mind of the court. Still the next one.
Next line. Huh? Sir, you are making everybody wait. Yes, tell me. Yes.
My lord, I have challenged the.
Today it's so many matters, so therefore
I am not taking that. My lord, only my lord, I have challenged the order dated 3 pending, discharging the petitioner matter in rejecting my application for discharge. In the meantime, my charge frame trial comments. So
what? Will withdraw it?
up to pass any order.
Charge has been framed.
Charge also trial comments.
Right. What you have challenged the cognizance order?
No, my lord, I have challenged the discharge petition. Rejecting my application, I have
Simply withdraw it, reserving your right.
also dispose of since trial comments, so raise all the point at the
Right. Okay. The petitioner had challenged the order dated 3/3/2023 passed by Special Judge Vigilance Bhubaneswar in TR case number 17 of 2013 arising out of Bhubaneswar Vigilance case, Vigilance PS case number 19 of 2009, whereby the court below had dismissed his application seeking discharge. Mr. Amitabh Tripathi and count for the petitioner submits that. Meanwhile, charges has already been framed against the petitioner and trial has already started. Therefore, he doesn't want to press this petition.
For that reason, you are not.
In view of the aforesaid development, the petitioner is granted liberty to raise all his points before the court below at appropriate stage. With this observation, the petition is dismissed.
Item 3,
May I please, my lord? The POSCO and compromising petition have been filed, my lords.
Where are they?
They are coming, my lords, they are making pass.
Let them come.
12 p.m.
164, get ready 164 statement.
Yes, my lord.
164.
They married or what?
No, not married. Compromising is there, my lord. Both
They
are,
are married at different manner.
they are, the wife and the husbands are married different separately and
Separately.
separately and blessed with their children. Also.
Bring them, bring.
Joint evidence there.
12 o'clock. Yes.
12 o'clock, my lord.
item 4,
Yes.
May I please, your lord?
Yes.
Kindly post this matter after vacation, sir.
Oh. That is why you were so curious. 3 times you mentioned.
I thought I was late.
item
Okay.
5, item 5,
311 petition wala reject.
No, non-appeared last time.
Boxers.
Right out. On 2/5/2024, none appeared on behalf of the petitioner. When the matter is called up today, again, nobody has appeared for the petitioner. Therefore, the matter is dismissed for non-prosecution.
item 6,
May I please, my lord? The 307 and compromising joint affidavit is filed for that both of the party are agreed to compromise.
Injury?
My lord?
Injury simple or grievous?
Injury report.
Injury report. You get ready injury report and bring it.
Yes, madam. I have the hard copy of the injury report.
Huh?
Hard copy of there.
Simple or what?
Yeah.
They are there
Grievous.
right now.
Grievous, my lord.
Grievous.
Happy to both when they are agree marriage so the relative. There is some misunderstanding, but that's
Misunderstanding grievous.
informant is the father of the injured. He has already died, but the injured has come and compromising the joint affidavit for that reason. I'm saying.
No, they are there.
Yes, my lords. There are 4 petitioner and injured.
Affidavit?
Yes.
Gunshot injury.
My lord, that's the matter.
Gunshot injury.
One is belly being fired by one. Hatipatro. Hatipatro. From his gun to kill his to the sudden cause. Who is that Hatipatro? Prabhat Hatipatro.
प्रभात के एक पक्का सर एक पक्का सर
Ukila Dumila.
ओकेला
Naresh Patania ki injured.
Naresh.
He is injured.
He is injured.
Yes, my lord.
His father was the informant.
His brother is on.
Brother informant.
Elder brother informant, he was dead. My lord.
But gunshot injury, how to do? Yes,
gunshot injury grievous in nature.
grievous injury.
Compromise.
Compromise doesn't mean that you murder someone and thereafter you compromise.
No, no, I'm
Rape
not
someone and compromise. It is a offense against this society. I just, if there is simple injury, I don't see it. I just allowed.
That's true, my lord. But they were relative and some. That reason I'm saying.
You just
Arms are there, my lord.
Huh?
Arms are there.
Yes.
Arms are there.
And
Do you have any judgment to support?
but one judgment is there, my lord.
Huh.
In case, but not gunshot, my lord. Not gunshot injury. Other
Do you have any judgment? Gunshot.
gunshot injury.
2 o'clock I'll take. Show me
नहीं है
some-
छोटे gunshot injury तले में ही करें.
2 o'clock I'll take. Show me some judgment, otherwise it will be, he set a wrong precedent. Show me a gunshot injury, grievous. Matter is settled. Court under 482 can quash.
Supreme decision.
Yes.
Many judgment is there. Get some judgment. so that I can record it.
appeal stage में ही
Record it and tell him to get ready to pay at least 10,000 rupees
to the injured.
injured. Get that money and come at 2 o'clock.
Nirala sir.
Judgment and money both.
Even if you appeal to exchange.
Item 7.
You can't let these they are the people and they're against the society. I tell you.
Concept, my lord.
Unfortunately, this man out of pressure, I don't know. Out of pressure, is doing whatever.
My lord.
No,
You may say no.
my lord. Because they're relatives, so they come.
You may say no.
My lord, my lord.
Okay, 5 minutes you will interrogate, he'll tell.
No, my lord. That's it.
2 p.m. my lord.
At
This
2
is
p.m.
what is the reality. Look at them. Look at them, then you'll understand. Come with some judgment. If you have some judgment and get some money, pay 10,000 rupees to him and armed with some judgment where in a gunshot injury, grievous injury,
nature.
but this settled, I can cost. Yes.
Item 7.
2 o'clock, I'll take it up.
My lord.
Yes.
My lord, this is a case of Mathiri police station in Malkangiri.
Yes.
Manoj Ghoshal, the petitioner, was implicated in this false case. He was arrested and he has already been released in bail last year. My lord, the factual matrix of this case, one Khakan Sarkar from Rajasthan, who is a Muslim man, he had come to Malkangiri district, the town Kalimala, and settled there for ganja smuggling. He had a bolero, silver color bolero of his own, which he had brought from Rajasthan. For repair purpose, he was bringing that vehicle to this petitioner's garage, diesel garage, Manoj Ghoshal, in Kalimala. After bringing the vehicle 2-3 times for repair, he persuaded this garage owner, why don't you purchase a bolero jeep and give us on rent? I will pay. Yeah. Thereafter, a bolero jeep was purchased by this petitioner because he had a diesel.
What do you want in this petition?
I want question.
Watching that to NDPS and with all heavy loaded story.
My lord, not a single gram of ganja was seized from this fellow. And not only that, after the kingpin of this smuggling and all his associates who were caught red-handed by the police people in Malkangiri, in Mathili area, were released on bail. After 33 months, this man was taken out from his garage to be made an accused. Not only that,
Nobody can ascertain at this stage.
Sir, I'm giving.
You want me to conduct a call every witness and examine here?
I'm giving the very vital witness because the vehicle which was seized
Sir,
from.
I can't quash it. You have to go to the trial court and tell all these things.
That is subject matter of trial.
482. How can I go into all these things?
At least, my lord, the police could be noticed to because they have done a grave irregularities by seizing a vehicle which does not belong to this man, but this man was implicated for the number of the
You
vehicle.
know, because these are the facts, you know.
I have gathered the proofs. I have gathered the proofs and I'm giving it to the honorable
No,
court.
I can't in 482 perhaps go into all this thing at this stage. You please
You are dependent at the time of framing a charge.
framing of charge, you can tell all
Charges.
Charge family.
Charge family.
Against it.
Against at the time of framing the charge, this man was not arrested. He was arrested.
Charge हो ना. Charge in a beach में
to raise all the points before the court below at appropriate stage with this liberty, this is disposed. Yes, I have given the liberty. Next.
Item 8.
Fast. Start fast today. No, yes, in the interest of justice, yes.
Item 9.
My lord, item 8. Item 8.
Arjun Labra.
No, your lordship, I am challenging the cognizance ordered 1/9/2022, my lord. As
Item 8.
Item 8.
Yes.
There is no allegation regarding the against the caste of the informant, but the London court below took cognizance in the under section 3 Act.
You argue that and charge. Why should you challenge the cognizance order?
That happened, my lord. I have the annexure 2. There is a Foishalan executed between the both the parties, and they are willing to settle the matter. So your
You
lord,
tell me whether you want this quashing on the ground of settlement or on merits.
my lord, the party may kindly issue notice to them, and thereafter they come and the matter will
Shall I
be.
issue notice? Open to. Yes. Next.
Item 9.
Allot kindly to the annexure 3, basing upon the amicable settlement, filed for quashing of the proceedings.
What is the offense? 376 2A.
Allot, charge sheet has been submitted, only 498 is.
Where are they? Are you call them?
It's already filed.
Call them.
The parties. Okay.
When?
One, I will just inform.
You tell them 20th.
20th. The opposite party number 2, his lawyer can be here.
No. Parties has to be there because
Okay.
You have filed another PC, excellent.
For better application, I have withdrawn that and this.
Okay, anyway, you bring them whenever you bring.
20th.
20th. Settlement. Yes. Come. Next. 10.
10 not 12. Item 12.
Yes.
Item 12.
Defects are there. 12. Non-APS in the interest of justice. Yes.
13.
Yes.
Item 13.
Defect is there.
No.
Display.
139 Act.
13.
12 charges है तो
12 charges.
Non-APS. For petitioner did. Yes.
14.
My lord, item number 14, my lord. I'm on VC, my lord. Item 14.
Yes.
My lord, your lordship may kindly see page 16, my lord.
16.
16, and that is annexure 1.
Yes.
Your lordship will see at annexure 1, this is a work order by Dadichi Infrastructure Private Limited to the complainant, Uma Services Private Limited. I am no way concerned with this work order, the present petitioner.
Who
Then
are you?
Your lordship may kindly see page 24.
Pradeep. Your name is
Pradeep Pugulia.
Pugulia. Yeah.
Pugulia.
Yes.
Your lordship may see annexure 3, page 24.
Yes.
Your lordship will see a notice, a notice for under NI Act from the complainant to me, to petitioner.
Yes.
Petitioner is the whole-time director of one RDB Realty and Infrastructure Limited. Now,
Right.
your lordship at para 2 will see a check number of 439630. Para 2.
Yes.
Now, your lordship may kindly see page 28.
28.
Yes.
Yes.
Similar notice has been sent to one Sundarlal Dugar. Your lordship will see para 2, check number is same.
He is also director of
He's
RDB.
also RDB. my lord. Now, interesting fact is your lordship will find at the next notice, that is page 32.
Yes.
Pawan Kumar Sharma, director, Dadichi Infrastructure. Your lordship may see next page 33. Same check number. Para 1.
What is the relationship between the Dadichi and the DRV?
Dadichi and RDB, that is me, that is the petitioner's company. They are independently have some business, barring the complainant. So one of the check which has been issued to from RDB to Dadichi has been utilized by the petitioner.
That's the 15 lakhs check.
That was never issued to Uma Services Private Limited, who is the complainant. He is unable to explain the relationship. Your lordship may kindly see page 37. That is the complaint. Para number 3. It starts with that the complainant accepted. Your Lordship will get it at page 30.
Order and completed the work.
The complainant accepted the order, that is annexure 1, completed the work, and the accused issued an account pay check signed by accused 2. The relation between the complainant and the present petitioner is nowhere explained. Cognizance has been taken without recording 202.
But you are the you have issued the check.
That has been never issued to me. My relation is with RDB is related to Dadichi, not the complainant Uma Services. We are no way concerned with Uma Services.
That's right. But have you issued the check or not?
No.
That's what the complaint says.
Yes, the complaint.
Pradeep Kumar Pugulia issued the check.
Yes,
Signed
that is
by.
Signed by.
Where is your reply to the legal notice?
My lord, so far as the reply to the legal notice is concerned, my lord, that is not there.
Then cognizance is rightly taken.
My lord, cognizance has been taken. Your lordship.
Why have you not replied to the statutory notice given to you, saying that I have nothing to do with Uma Service?
That is there, my lord.
Then prima facie case is made out. You face the trial and get out of it.
My lord, may I make a humble submission subject to your lordship's consideration?
Yes.
In the meantime, 2017 was the cognizance order. In the meantime, my lord, the parties have somehow, my lord, still in the business. The RDB and the Dadichi.
What do you want?
Your lordship may issue notice if it can be settled since it's a monetary dues.
A cognizance order is
page 40.
Shall I send you to mediation?
Your lordship may kindly we can explore that because it's a monetary due.
So simply I will issue notice. Let us.
Yes.
Issue notice. Simply I will not say anything. You should have replied to the statutory notice, then you would have been
absolutely.
That's the whole difficulty. Yes. Anyway.
Item 15.
Issue notice.
Obliged.
My lordship, on behalf of Advocate Manoranjan Mishra, he is just arguing on another matter. Maybe matter can be taken at 1 o'clock or right after lunch.
1 o'clock, how many matters I'll take?
After lunch.
Let it be at time, we'll see. Yeah?
After a long time, we got it. So.
You'll pass over. Yes.
Item 17.
Yes.
Item 17, my lord, taken up on 16, my lord. That's because, my lord, the petitioner and the opposite party number 3 now living together, my lord. The opposite party number 2, the father-in-law of the petitioner, my lord.
You have settled the dispute?
Yes, my lord. Already now the residing together, my lord.
Bring them.
On 16.
16. Yes.
Obliged.
Item 18.
That day, if you seek time, then I'll impose cost. Because at the cost of other matters, I am taking it.
Taking instruction from the opposite party number 2, my lord.
They are the accused and informant.
Vigilance case it.
And their mercy we will take. What is this? Yes.
Here, my lord, I have challenged the order taking cognizance in the vigilance case. But I thought, my lord, it would be better, my lord, if my lord would direct, because trial has already been started and it's pending since 2011. My lord may direct to dispose of the trial within this stipulated period.
How many
Vigilance
matter, my lord. Vigilance matter.
How many witnesses are there?
My lord, 10 witnesses have already been examined.
Out of?
Since 2017, no witness has been examined after that.
Out of how many witnesses?
Yes, my lord. Just it witnesses number is number is 16 and 19.
Right. Albeit the challenge in this petition is to the cognizance order. However, Mr.
I confine my prayer to this.
Yes.
I confine my prayer to dispose of the trial within.
Because see, 19 witnesses, 10 have already been examined. 2017 onwards, nothing is happening right now. Cognizance order dated 14/12/2011. However, Mr. DP General Senior Counsel, submits that.
He confines his prayer ballot, we say.
Submits that the trial.
There have been comments and around 10 witnesses have been examined. Right?
Trial of the case may be directed to be to be
Completed.
completed. Completed at the clear court. The out of 19 accused, cited the charge is about 10 accused. 10 accused have already 10
Witnesses.
10 witnesses have already been examined. After 2017, the trial is moving in its next phase. Therefore, Mr. Hull is making the correct disposal of the trial, taking into consideration the facts of the case and the fact that the FIR was registered way back in 2008. The trial court is directed to do well to see that the trial is concluded as expeditiously as possible. Preferably within a period of 6 months.
Ballot.
Preferably 6 months.
ତାଙ୍କର କେତେ ସାକ୍ଷୀ ଥିବେ ମୁଁ ଜାଣିନି ତେଣୁ ତାଙ୍କର
6 months ago, I mean,
It is made clear that the accused are not seek unnecessary opinion. Yes.
the copy that to communicated to the trial court so that
Trial court, the order may be communicated. Thanks.
19.
Yes. Yes.
19, my lord, I am for the opposite party, my lord.
Who is for
Matter relating to 138 of NI Act, my lord.
My lord, that is instead of 2017, that will be 2021. No witnesses.
2021, 17.
There should not be a wrong.
21.
Matter relating to 138 of NI Act, my lord. The present opposite party is the complainant, my lord. And the law and court below taking cognizance of offense against the present petitioner. The present petitioner challenged that order before the law and trial court as well as the revisional court. Both the courts below rejected the prayer of the petitioner. Thereafter, only for the intention of the prolong the trial and non-payment of the check amount, the petitioner before this case before this honorable court.
What is the check amount?
Check amount 10 lakh, my lord.
He challenging the cognizance order.
My lord. Both the court below rejected the prayer of the petitioner. Trial court as well as the revisional.
Where is that?
My lord, kindly see the revisional court order. Para 4 of the revisional court order, my lord. Para 4, page 4 of the revisional court order.
Yes.
On the contrary, Lord and counsel for the opposite party would submit that the present revision petitioner issued a check in favor of the opposite party on 10/12/2022 for a sum of rupees 15 lakh for discharging debt which she had borrowed from opposite party.
What is the stage up for the trial now?
My lord?
Stage of the trial.
Deposition ସାକ୍ଷୀ ଆରମ୍ଭ ହବ ସେଟାକୁ ବନ୍ଦ କରିବା ପାଇଁ ସେମାନେ ଏଠିକି ଆସି ଲେଖି ଦେଇଛନ୍ତି ନମ୍ବର ଯେ ଆମର ହାଇକୋର୍ଟରେ ପେଣ୍ଡିଂ ଅଛି ନମ୍ବର କିନ୍ତୁ ସାକ୍ଷୀ
Petitioner is the non-appeals for the petitioner. In the present petition, petitioner is challenging the order dated 7/9/2023. 7/9/23 passed by the Sessions Judge Koraput in criminal revision number 16 of 2023. Whereby his prayer challenging the cognizance order dated 15/3/2023 passed by JMFC Jaipur in ICC case number 39 of 23 has been rejected. So to appeals for opposition party number 2. The submit told to appeal for opposition party number 2 and submit that the trial is at the advanced stage. In view of the fact that the trial is proceeding in this matter, I'm not inclined to entity in petition.
Item 20.
One pass or parties are present gate pass packet correspondence ସେଥିପାଇଁ କହୁଛି compromise. One pass 130.
21.
Application under section 205 has been rejected under annex 3. Order dated 8/11/2023.
Yes, yes, sir.
Yes, annex 3, order dated 8/11/2023.
Yes.
At page 17.
Yes.
This is my 205 application has been rejected. Against that, I have come. This is a case under section 138 of NI Act.
I issue notice.
I am appearing, my lord.
My friend is appearing today.
205 in 138.
I am, kindly see case number 2010, year of 2010. Argument was fixed for 2012.
Now it is the final stage.
In the stage of argument,
So
my
then
lord.
final stage, what the accused will do, the lawyer will argue.
No. Can you see the order?
One day default. In fact,
No, my lord. Can you see the order?
Come. In the year 2010, person to summon accused appeared and filed a 205 application. It was allowed. He continued till 2023. Lawyer was also representing. One day default, NBW was issued. Lawyer did not take any steps for which NBW was issued. So accused filed a petition 205 application. It was rejected. I have come against that. This is the entire case.
See, I will bound him to appear through counsel and finish it up. Unnecessary. Why?
My lord, my respectful submission, my lord.
It is in your interest, sir, I'll tell you.
My lord.
You keep on fighting, you get nothing. It is a 138 matter. Better that he should appear to counsel and finish the matter.
Complete.
Stage of argument, my lord.
That is why I am saying he is not going to argue. The accused is not going to argue. The advocate is going to argue. No adjournment will be given.
Yes.
Okay. Right on. The petitioner is agreed by the order dated, which is that order 8/11/2023, passed by the learned HDJM Kurda in ICC case number 200 of 2010. The petitioner is accused in the complaint case under section 138 NI. Mr. Pradhan, that is also for the petitioner, submits that the matter is at the final stage of argument. Final stage of argument. He undertakes before this court that his client would appear before the court through counsel and conclude the trial without seeking further adjournment. Mr. Sorry, I forgot your name.
Rajiv Behring, sir.
I'm so sorry. Mr. So, the appealing court, the opposite party, submits that to the trial of the case is prolonging because of the non-cooperation of the petitioner. Without going into the objections raised by the opposite party in the present case, I am inclined to allow the petition moved by the petitioner under section 205 CrPC and direct the petitioner to appear before the trial court through counsel and cooperate with the trial. Cooperate with the trial without seeking unnecessary adjournment.
And we don't have any question.
NBW issued against the petitioner by the order dated
6/8/2022.
6/8/2022.
Item number 72, my lord, similar.
72 also same.
Is what? Item 72, same order. And go and participate and
I am participating.
at least if it's
Case will
convicted,
be closed.
140
my lord.
use and get some money.
Yes. Case will be closed.
छोटे जिनसे बेकार time खराब करेंगे.
Item 72.
72 also.
CRLMC 190/2024.
Same order.
Same order. Only case number will be changed.
ICC case number.
No adjournment should be given to the.
I have written very clear with a very clarity. Yes.
22.
Lots of item 22 kindly pass on. It's a compromise matter.
Parties are there.
नहीं parties नांत से
नांत तो adjourn करो. नांत adjourn.
Adjourned, Passover.
Passover today is not possible.
22.
Why Passover?
Senior will add. Senior will add with me.
Or senior will have Passover for next after vacation Passover.
Your matter is compromise, passing of cognizance.
Passing of cognizance.
The parties has to be there, no? Parties.
Are you
Are you bringing the parties?
Yeah, parties no.
Let my lord urgent to another.
Next.
23.
23, my lord, on behalf of the conducting council, I pray for an adjournment
Very good.
after vacation.
Very good. Very good. Yes.
24.
44 my lord, Passover.
What is the
Senior.
matter?
I have no power, my lord. Senior is coming.
24. Passover. Urgent to Passover can time.
Aji Passover magon kuri.
Asu sir asunte senior asunte sir pawan.
Ki?
Arjun Bear.
Huh?
Arjun Charan Bear.
What is this matter? Let us see. Where is your file?
Question of a proceeding, my lord. A question of proceeding 341, 323, 294, 354, 506, 34, my lord. Cog has already been taken, my lord.
Achha.
So,
Return कर दे भाई. Monday, Tuesday, go. Tuesday, go. It's good. 21st. Yes.
25.
Item 22 after lunch, the both parties.
He said parties are not there.
Yes, my lord, party are here.
What are you? What is the offense? What is the offense?
307, my lord. So injury is simple, my lord.
Simple.
Yes, my lord.
Call them.
Yes, my lord, after lunch, my lord.
22. I asked him that he said that no parties are not there. Yes.
25.
25.
25.
Yes, madam.
Lordship, in this application, my cross-examination has been devoured by the court below, for which the application has been filed. That the fact is that there is a complaint case and there is a fraud of.
You are the accused.
Yes, I am for the accused. My cross-examination to cross-examine the complainant has been devoured.
Where is that?
Lordship, that is the order dated 6/12/2023.
page.
6
No, where is the? No.
Annexure 3, Lordship.
Where is the testimony, madam?
15. Page.
Page
Order.
number 15.
20/11/2030, my lord.
Lordship, in the as the conducting counsel for the accused took some time on his personal grounds from 2 to 3 days.
138 case.
Yes,
Yes,
139.
issue notice, let us. Issue notice. Yes. Yes. Next.
26.
May I please, Passing of cognizance, my lord, and dated 18/9/2023, my lord, adjudged annexure 1, my lord.
Where is the charge sheet, sir? You have not filed charge sheet.
Only I raised my all the point at time of framing of
Let counsel for the petition seek withdrawal of this petition with the liberty to raise all the points at the time of framing of charges. With this liberty, the petition is disposed.
27.
Instead of withdrawal, my lord, in course of hearing.
Sorry?
That's instead of withdrawing, course of hearing, I have submitted that.
Disposed of. That's what I said. Disposed. Yes.
Let's say in item number 25, I may be pardoned to correct the cause title by adding the complainant as a party. I have not made party to him.
Very nice. In a complaint case, you will not make complainant in parties. This is correct. Let the counsel for the petitioner seek to implement that for the vice chair. Yeah.
May I please, Lords?
27.
May I please, Lords?
Hmm.
In this petition, I am challenging the order dated by 7/2023, my lord, under section 457 of CrPC, filed by the manual of allegation, my lord. My vehicle was used in committing offense punishable under section 52A. Though my vehicle was stolen by anybody, thereafter I filed, my lord, complaint letter before the IAC, my lord. under Annexure 3, my lord. Kindly see, my lord.
What are you challenging?
Challenging, my lord.
By this order, what happened?
What about, my lord, allegation, my lord, that my vehicle was used in, my lord, the committing offense under section 52A, my lord.
What was your petition, sir?
My lord.
What was your petition before trial court?
Yes, my lord.
What have you asked before trial court, which was rejected?
My lord, I have, my lord, filed to release my vehicle, my lord.
457 application was
My lord,
rejected.
in CMC, my lord.
Okay, now confiscation proceeding is there.
My lord.
Confiscation
No,
proceeding.
my lord, it is
Yes, my lord, confiscation is going on, my lord, under Annexure 2, my lord.
Don't participate.
Yes, my lord.
You have written confiscation proceeding is case number 28
My
of
lord.
2023.
My lord.
Won't participate. Participate there.
Yes, my lord. And similar case already decided by this honorable court, my lord. Kindly see, my lord, the judgment dated 13/7/2020, my lord.
What do you want? Where do you want to prove? Which paragraph? Which paragraph?
My lord.
You are quoting which paragraph?
This is, my lord, similar case to my case, my lord.
Are you thorough? You prepared the case or not?
Yes, my lord.
Tell me which paragraph you want to rely.
My lord, this is the case, my
Do you
similar
want
case, my
me to
lord.
read entire judgment?
Yes, my lord.
Sir, if you are relying upon a particular judgment, you must tell me which paragraph you are relying upon. Not that you give the entire judgment, I'll keep on reading judgment. You prepare, adjourn it.
My lord.
Adjourn. Simply adjourn it. Keep this judgment in that file. Prepare and come. Okay, next. 28. Yes.
My lord, 28 on behalf of on behalf of Mr. Udit Ranjan. Charge sheet, Mr. Udit Ranjan on behalf of charge sheet file कराएं. In course of the day, आज today file कर देंगे. Short date.
You want to file charge sheet? Let go to the petitioner.
In course of the day.
It's time to file the copy of charge sheet.
Short date.
You can do so. Yes, next.
29.
Item 29. May I plead, my lord? I am on BC, my lord.
Yes.
My lord, this is petitioner implicated under section 66E and 67A, my lord. This matter is amicably settled, my lord. Kindly short adjournment may be given, my lord. Party will be present on the court.
Adjourn. Yes.
30. No, 33.
30?
33.
33.
Matter 33.
33.
33.
Sorry.
33.
Yes, item 33.
Yes.
May I please, your lordship? Petitioner has filed the aforesaid CRLMC. This CRLMC for quashing of GR proceed.
Speak loudly.
My lord, petitioner has filed this CRLMC for
Yes.
quashing of proceeding in GR cases.
Why?
My lord, this proceeding has been initiated on the basis of a complaint case. Petitioner number 2 is one of the brother of the complainant, and petitioner number 2 has been given an adoption, and now he's the son of his adoptive father, but some of the land has been recorded in his name, which belongs to his natural father. He has sold some portion of land as per his share, and the complainant allegation is that it is a fraudulent transfer, and there is a civil suit is pending before the London Civil Court, Puri. That's why, and there is a chance of compromise, man.
Let's come after compromise, my lord.
Tell that. Compromise, if family dispute, there is a compromise, then will you bring them here? No.
That's it.
Right off. When it comes to the petitioner submits that the dispute is arising out of a dispute is arising due to the land. Not for the public sector, the case is arising out of a family dispute regarding some land. There is a probability of a settlement between the parties, as all of them are related. As all of them are related. Issue notice written.
Further proceeding be stayed.
No further. Yes.
34.
This is item 34 on behalf of Mr. Porida. I pray this matter after vacation.
Vacation.
Mr. Porida has some difficulty today.
Okay, no problem. 35.
36.
Okay. 36.
May please, Your Lord.
Yes.
My lord, here the 457 application was rejected by the STGM Jaspur, and in revision it was also confirmed. Kindly have a glance to the running page 18.
457, huh?
My lord. Running page 18, the order of the London STGM, my lord.
Yes.
Paragraph 3, my lord. This is a case for release of the seized copper and brass material on interim JMA. The IIC Kuakia PS submitted a report stating that during investigation on so-and-so about to 11:30 PM, the IO of city case number so-and-so seized approximately 375 kg of copper and brass material while the same was being transported illegally. The London Council submitted that, as per the report, at present, the seizure of copper and brass material are not required for the purpose of investigation. This is also report of the police, not report, my lord. Next, my lord, the petitioner in support of his claim has filed some tax invoice, has submitted that those tax invoices are well proved. Fact of prima facie ownership of
in respect to the brass and
my lord.
But this is so reveals that the police has 20 numbers of gunny bags containing copper wire and aluminum so out of which 11 total 760 kg.
My lord, my invoice, my lord, I have annexed my GST
375.
My lord,
you are claiming 375. This is 760.
My lord, 2%, accused 2%.
What about the other?
Other accused person, he filed the application before this honorable court without any document, and my lord remanded the matter to court below. Court below se document देई तार मध्ये रिलीज हे गेलानी.
केते
तार जो ता पार्टटा सेतरे ता बस्तार मध्ये ना ले
रिलीज.
Apart from the
totally 760.
My lord,
and you are claiming 375.
More 375 की बात देगी तार रिलीज हे.
Show me that.
That order I have not, but the High Court order is with me. जोटा रिमांड हे गला. After remand,
I'll remand this also.
Mine.
I'll remand this also, so that the remaining thing will be. I'll remand it.
Only with the observation that the petitioner is having the valid GST.
It is there already. He has written it.
My lord.
Valid GST.
Whatever you also pass the order, the same order may be passed in this case.
ना सेम ऑर्डर जोटा देइचन ता बाद जोटा रहिछ मत दे देबे मु तो देइछ ना एथरे and my calculation is 375 मु जो देइछि
375
मोर जो इन्वेस्ट गुडा देइछि वर्तमान
I don't know, let the trial court do it.
My lord.
সেই কেসরে মোর মনে আছে সেই কেসরে আপন কইলে ইনস্ট্রাকশন আটো ইনস্ট্রাকশন আমার দিয়েছিলে 7 পর্যন্ত ইনস্ট্রাকশন আসতলা রেস্ট পার্ট আমার পাখের নথিলা যে আমার পাখে সেই ডকুমেন্ট দেই পারু
তেনগুরা আমি রেলিগেট কর দেলু
বাস
ট্রায়াল কোর্ট হ্যাজ নাও ডিসাইডেড fair enough.
সেনকশন অর্ডারটা হবে
Right on. The petitioner is challenging the order dated 18/10/2022 passed by AGM Jajpur in this case number so city case whereby his application under section 457 CrPC seeking release of 375 kg of scrap brass and copper material has been released.
And confirmed in the division.
And which the said order has already been confirmed by the
by the London distance.
Confirmed.
By
Where is that order?
My lord, page 20.
20. Confirmed in the Regional Court order dated 12 January 2024. The petitioner is disabling both the orders. Mr. Naik, and counsel for the petitioner, submits that there were two claimants to the entire cigarette scrap, totaling to 760 cases. The co-claimant, both of you are accused.
My lord.
The co-claimant, oblique the co-accused, had approached this court by filing CRLMC number 387 of 2024, full stop. 24, whereby his application under 457 CrPC was also rejected by the court. This court, by order dated 10/4/2024, remitted the matter to the trial court for fresh disposal of the application. Pursuant thereto, the level court below by order dated.
Order dated, I have only.
Level court below. Mr. Naik submits that pursuant to the order of this court, the trial court has now allowed the application of the co-accused of the co-owner of the scrap and release his part of the seized brass and copper and brass. Copper brass. The present petitioner is claiming that he is the owner of 375 kgs of copper and brass. Mr. Naik further pointed out that the trial court records in the impugn order that the seized copper and brass materials are not required for the purpose of further investigation. And insofar as the ownership of the seized articles are concerned, the trial court has recorded that prima facie the ownership in respect of seized brass and copper material to the tune of 375 cases appears to be of the petition. Which of the petitions. In view thereof, Mr. Naik prays that this application may be allowed and matter may be demanded back to the trial court for fresh consideration. Taking into consideration the impugn order also comes to acquire and matter is demanded back to the trial court for fresh consideration of the application 457 CrPC moved by the petition.
On production of the copy of the invoice, the court will consider whatever that is. Yes.
37.
Yeah. 37. None is there. I'll just take off the 37. What is this? This is division bench.
29 with 38.
37.
37.
That's private.
Why the order of division bench is there? There's some confusion. Hmm? See, both the orders of hmm? I number so black change of somebody. Mata to criminal name. Huh? Clarify it look like why. Huh?
38.
How can my Mata be converted to criminal? Yes, let's check that. Okay, 38.
38.
May I please your lordship?
Yes.
Last package on reversive has. See, this is the, I am challenging the order taking cognizance under Annexure 4. Lordship may see.
Annexure 4.
Annexure 4.
Yes.
Running page 31 to 32.
Okay.
Your lordship may see.
Yes.
The London Master has taken cognizance under section 370A, 3, 4, 5, 7 of Immoral Traffic Act. My submission before your lordship is that in the FIR I am not in the accused. Subsequently, my name has been added. As per the my name has been added, allegation against the all the official witnesses who are all the hearsay witnesses that the I procure the two ladies, that is
the girls.
Yes, procure, but that two ladies have not been specified for the police. No one statement has been recorded. They denied, and then no direct evidence against me except hearsay witnesses. Nothing against me.
Yes.
My lord, as per your direction, I have obtained the CD, my lord, meantime, and 161 statement of eyewitness and 161 of complainant are available, my lord. Only I have to obtain the specific statement of victims, my lord.
See, for the victims have stated nothing about.
No,
him.
there is no any
Then where
evidence.
is the question of 370?
Yes, no, my lord. Regarding the 161 statement of a victim are not available at present.
Mr. Rahul, the counsel of the state, submits that he has got the case diary. However, the 161 statement of the victim of a lady, victim are not available with him. He seeks adjournment on that count. Adjournment.
And the IA University.
Yes, there is an IA. What to do?
Yes.
In fact, my lord, what my learned
What is the stage?
Stage is some one accused person has not appeared and other accused person go on bail. I have also gone on bail. Therefore,
they are on bail.
The someone has been free for starting.
Only appearance. Only appearance stage.
Yes.
In respect of these petitions.
Yes, yes.
And in terms of Mr. Immoral and counsel for the petitioner submits that he will appropriate application to court below seeking adjournment to assign that the matter is depending on the court. We may such application. You move an application there for time even for adjournment. In the trial court, you move that application saying that the matter is sub judice. That I have indicated. Yes. It is indirect stay.
Yes,
not direct stay. Yes.
39.
Petitioner is the informant man. He has lodged a FIR under section 420, 294, 323.
You are the informant.
Yeah, I am the informant. Your lordship.
First time you came for informant. Every time you are. Yes.
Where are the your lordship can have page 16, man.
16.
My lord. Order dated 6/12/2022.
What is this order?
My lord,
The law and court below is adjourning matter in a routine manner. 4 months they are giving adjournment manner. I am a poor lady, my lord, and my property was mortgaged by the accused person and take loan from the bank, my lord.
See, we don't know what is the load of that court. How?
My humble submission, your lordship kind of runs. That matter was put up on 6/3/2022, but it was put up on 18/7/2023.
Which one? Where is that?
16, my lord, case 16, your lordship, may.
1/6, huh? Yes.
Order dated 6/12/2022, my lord.
6/12/2022. Yes.
Next, last line, your lordship. Put up on 6/3/2022 for further orders. But it was posted on 18/7/2023.
Many a time this happens. What to do? That
My
judge might be on leave or something might have happened. How do I know?
No, it's that your lordship record is put up today as not put up on date fix. DA is warned. Put up on 13/11/2012. 4 months adjournment is giving space to 1 month, my lord.
So what do you want?
Expeditious trial. That is the limit.
I don't know how many witnesses are there. What is this case?
My lord, charge sheet already submitted.
Well, show me charge sheet. How many witnesses are there?
My lord,
you have not filed the charge sheet also.
No, sir, my humble
Tell me how many witnesses are there. Accordingly, we can think of expediting.
My lord, there are 14 witnesses.
14 witnesses. FIR is of which year?
21 years. 19, sorry, 19. 5 years.
I'll just let us issue notice and keep it immediately after vacation.
Yes, sir.
We'll examine.
Right.
Otherwise, I give a direct.
Your lordship, call for a report from the report. Yes, obliged.
Issue notice to opposite party. Which court is that?
SDGM Nayagarh.
SDGM Nayagarh is directed to submit a report regarding the status of the trial up to the present case. The trial of the case arising out of Nayagarh PS case number 167. No, trial of GR case number 561 2009. Report immediately 20 June.
I will take notice to the opposite.
You take.
Informal accuse is not necessary. My prayer limited prayer.
Then accuse also necessary. Why to leave it like that?
Mal.
He may challenge it somewhere.
Item 40.
Notice करके report मांगेंगे. ठीक है.
Item 40.
Yes.
May it please your lordship. My lord, the petitioner challenging the order passed by the SDM under proceeding 144 CrPC, wherein the learned SDM, contrary to the provisions of 144, like a civil court, handed over the position to the OPs of the disputed property. And it's, my lord.
Which part?
My lord, annexure, my lord, page 46, 47, my lord.
Yes. Yes, Mr.
My lord, it is purely, my lord, the situated sub is that the disputed sub is situated in a government land, my lord. And both the concerned members, they are fought each other to running that sweet stall in the market, my lord. So there is every chance of breaking the peace of
to that extent is all right. But how can the magistrate,
yes, my lord,
subdivisional magistrate, direct eviction? I see so and so hereby directed to promulgate the order on the spot and putting the registered flag with the help of local revenue inspector, serve the order of parties related so and so. Tahsildar so and so is hereby directed to depute local RI to the spot for execution of this order. Now, where is this? There is no eviction.
My lord, kindly see at page 47, page 47. Page 47, annexure 5.
Okay.
My lord, kindly see the learned magistrate relying on the version of mother, this the common ancestor of both the parties. That is the father of both the parties was running a sweet stall in a government land.
Chalo, we'll issue notice. See.
My lord.
We issue notice. Let us see. Issue notice. Next. 43. Yes.
May I please?
Yes, sir.
I am for the opposite party, my lord.
Hmm.
In this matter was listed on 6/5/2024. On that date, petitioner was absent, my lord. This
None
matter,
appeared.
my lord.
None appeared on that day.
No, my lord.
Madam.
This matter is similar to item number 19, my lord. Both the
I'll
petitioner,
just dismiss in default.
my lord.
I'll just see on the matter was listed on 6/5/2024. None appeared for the petitioner. Mr. Mahapatra, J. Mahapatra, appeared for opposite party number 2 on that day. Today, when the matter was called for hearing, none appears for the petitioner. Mr. Mahapatra appears for opposite party. It seems the petitioner is not interested to proceed the case. Dismiss in the dismiss. Yes.
44.
Petitioner is informed, my lord. The owner of a truck, my lord, and having a wood house, my lord. Or my lord, on 30/12/2021, my lord, his truck was loaded with timber, was gone to Raipur, my lord. But on the way, my lord, assistant forcibly assembled the driver and took the truck along with the timber, my lord. Therefore, affair was lost on 9/8/2020. During investigation, truck was seized from the accused person, but astonishingly, final form was submitted is a mistake of fact, madam. Page
File protest petition.
Page 23 is the
File protest petition. That is the
it
remedy.
is erroneously, my lord, on the face of the record.
That's right, sir. The remedy is protest.
Remedy can't. That is there, my lord. But
That is only there. Nothing else is there.
accused person, they are named accused person, seized the
Right,
truck.
you are absolutely correct. But if final form is filed, the remedy is the protest petition, not 482. I can't exercise.
With that liberty, lordship.
Yes. Then counsel for the petitioner submits that those specific indications were made in the. You are the informant.
My lord.
Petitioner is the informant.
Informant Jagatpur PS case no.
In
Jagatpur PS case number.
PS case number
394 of 2023. 23.
After investigation, closure report has been filed by the police on 5/10/2020. He is assailing the said closure report.
That is mistake of fact.
In the present. I am not inclined to entertain this petition because the petitioner has alternate remedy of filing protest petition before the court below. The liberty is granted to the petitioner to avail the said remedy, and hence this petition is disposed of. Yes.
45.
Yes.
May I please?
Yes, sir.
Annexure 1, my lord, is the impound order, my lord, page 9.
Cognizant.
Challenging the NBW, my lord.
As under NBW, 394 upon.
394, my lord. So, right to surrender, my lord, you will be face the trial.
NBW issued on
27/4/2012.
12, my lord.
Yes.
Absconder.
He'll face my
Absconder. NBW 27/4/2012.
My lord.
On or before 30th June.
My lord.
How much you will pay?
Lordship direct, my lord.
2012 means 1,000.
1,000.
1,000. Okay.
Grateful, my lord.
Yes.
66.
Please, your lordship. Lordship, the petitioner challenged the order of NBW at page 9. 33/2024. It is arising out of proceeding under section 110 of the
110 रे ଆସିଲେନି
warrant issues.
The petitioner did not appear. Proceeding under section 110 CrPC was drawn against the petitioner due to his default in appearing.
Not furnishing the
and not
bond.
furnishing the bond as required under law. NBW has been issued against him on 30th January 2024.
13 March
1
1330.
13/3/2024.
ଆପଣ ପ୍ରେୟର ଦେଖିଛନ୍ତି 30 ମୁଁ ପ୍ରେୟର ଦେଖୁଛି ତାପରେ ଆପ୍ଲିକେସନ ଲଗେଇବେ ପ୍ରେୟର ଦେଖନ୍ତୁ.
Mistake must have been mistake. Your lordship is
Mistake is only creating problem.
lordship is identifying that.
Be sure.
Maybe mistake.
30 ना
13/3/24.
प्रेयर चेंज करंतु नहीं तो
ठीक God bless. First paragraph like if read about good.
500. Next.
47.
May I please, my lord? My lord, I am in virtual mode, my lord. My
Yes.
lord, I am challenging the petitioner challenging the DB miss case number 115 of 2023, your lordship.
Who are you?
On the I am for the petitioner. Husband and mother-in-law, father-in-law.
Husband,
Mother and
father-in-law.
father-in-law. Mother-in-law. My lord,
Yes.
on the ground that, my lord, the marriage held on 15/7/2018, and the opposite party has the petitioner has filed the divorce case which has been dismissed by the Lennet court below. Thereafter, matter has been pending before the 147 of 2023. Thereafter, the present opposite party filed restitution of conjugal right and DB miss case, that is 115 of 2023, my lord.
Matrimonial dispute, let us see who issue notice. Issue notice.
My lord.
Next.
48.
My lord, there is miss case also.
48. May I please? Order dated 10/4/2024, my lord, challenge. Mr. 2 page, turning page 10, my lord. During the trial, my lord, the defense counsel filed a petition to call for attendance register of class 1 for the month of September 2014.
Please use the mic.
During the evidence, my lord, trial, my lord, the defense counsel filed a petition to call for a record, that is a attendance register of class 1 for the month of September 2014, my lord. Because my lord,
केस रे समाने कहउचंदी जे अटेंडेंस रजिस्टर टाकू एविडेंस रे आकार रे नेबे एग्जिबिट करिवे व्हिच इज नॉट एट ऑल accessible under the law, because the question is the attendance register is required for proving the whether the victim after the occurrence is going to school or not. This is not relevant.
because occurrence took place, my lord, 29. FIR was lodged after 8 days.
Even if she has gone, she was sexually assaulted, whatever. She attended the school means you nullify whatever you done.
No.
So suppose se jai the school kon tadra habo?
Her mother state that she is not willing to go to school, my lord. Therefore,
you confront with the mother.
Eta khali only to linger.
No chance of lingering, my lord.
That is the observation.
Only school is in that locality, my lord. Only one date, my lord. There is no question of lingering.
You take defense evidence.
My lord, already 2-9, lordship. Kindly see. During that 8 days period, it is vital whether she.
Where is your application?
Annexure 1.
Annexure
1. Page 7 and 8.
7 and 8.
Kichi got session table special case. Session table
And
case.
what provision you have moved? What do you?
Kichi no provision. Only application for call for the register. School admission register. You can, if you prove it on your defense evidence.
Unless that register is
I'll give that right to you right out. Petitioner appears to have moved an application. It is rare that I may be seeking recall. No, seeking
Call for the
call of attendance register.
Yes.
As per the schedule, attendance register
of UG
of class 1
Karkhandra
from the month of September 24 of
2000
Karkhandra PE
तेरा लिखा ही से नाटक
PS also. The petitioner has moved the application to establish the fact that to disprove the fact that the mother of the victim stated to have deposed before the court that after the incident the victim could not attend the schools. The next paragraph. The said application has been turned down by the court below by order dated
10/4/24.
10/4/2024. 10/4/2024. 2024.
Yes.
Inter alia. Stating agenda. Para page 11. para having heard.
Yes.
Having
Yes.
heard.
Having.
Paragraph click. And that's all. Okay. I'm not inclined to interpret. Therefore, the petition is however, it is made clear that dismissal of this petition shall not preclude the petitioner to lead his defense evidence.
Yes, defense.
In this thing.
Yes. Yes.
Defense
Yes.
evidence. You lead the defense evidence. Right. 49.
49, may I please, your lords?
Yes.
My lord, the petitioner before lords is for quashing of the criminal proceeding on the ground of compromise between the opposite partner 2 and him. And I have annexed the charge sheet and the injury report, my lord, alleged offense under section 307, 452, 294, 353, 307, and 506.
Injury report show me.
My lord, page, my lord, 25, my lord.
Simple or what?
Pardon, my lord.
Simple injury.
My lord, he is not the principal accused. One Ramesh Chandra Sahu, he is the principal accused.
Injury indicated simple.
A simple injury.
Yes.
My lord.
Party can't.
Party can't.
My lord, notice may we go.
Bring them, you are settled. What is the problem? Tomorrow, day after, whenever you want. Friday, Korantu. Friday. Friday, Anand.
Friday.
Friday. Yes. Yes.
May I please, my lords?
Item 3, na?
My lords. They filed a joint affidavit, my lord, compromise petition, and both the
What is this offense?
376 and 6 POXO.
6 of POXO, my lords.
Item 51 after launch, I'm playing your lords.
And passover is not possible. What is this matter?
Lordship,
Recall of the victim, my lord. 33.5 is rebar.
Urgent. Yes, next.
52. May I please, your lordship? The petitioner is filing this petition challenging the cognizance order dated 19/3/2024, my lord. Prior to this, I pray to have a glance to Annexure 2, my lord. Annexure 2 is the complaint petition filed by the OP number 3, my lord. Thereafter, this matter was referred to police under section 156(3). Police investigated the matter and submitted report. Your lordship kindly have a glance to page 27. 27.
Yes.
During course of investigation, it came to light that there is chronic land dispute between the Manas Mahanti, husband of the complainant, with cousin brother Ashok Kumar Mahanti, the petitioner. The disputed land is a joint property which was equally divided among them orally. So finally, whatever submitted report found that without 307 is there, but no medical report, nothing. So police found that is a false case. So final report, my lord.
Yes.
Final
protest petition was filed.
Protest petition filed, and thereafter cognizance was taken.
Show me the evidence of pre-summoning evidences. Show me the pre-summoning evidence.
My lord, only evidence of the informant, my lord.
Where is that? That is the basis on. You file. Letter counsel for the petitioner seeks an adjournment to file additional documents to substantiate his case. Urgent. Yes.
Sir, may I pray one thing, my lord? After filing of charge sheet, final form by the police, the police is again on the basis of the cognizance apprehending arrest the petitioner. So kindly protest.
Sir, you are challenging the cognizance order.
My lord.
The cognizance is taken on the basis of the protest petition. You have not filed the statement, pre-summoning statement. How will I know whether any allegation is there against you or not? What can I do? You have filed an incomplete petition.
150. That is with me, my lord. Your lordship will say.
Maybe with you. How can I help you? If you keep it with you.
ବାହାରେ ଶୋଉଛନ୍ତି ladies ଗୁଡା ଅଛନ୍ତି ଏଟା out of grudge ଦେଇଛି police ମଧ୍ୟ details are ଦେଇଛି.
Maybe you may be correct, but see, unless you file a complete petition, what can I do for you?
That is with me, your lordship.
And it is cognizance is taken in a protest petition.
Yes.
What is wrong in it? Allegations are there.
My lord, allegation there, but that was enquired by the police under 156(3), my lord.
That's right, but is there any legal bar?
There is no.
It's investigated, file a final report. And thereafter, a protest petition is filed.
My lord, that
And
is,
there are allegations against you, cognizance is taken.
my lord, that is admitted, my
What is
lord.
wrong in it?
My lord, I may pray one thing, my lord.
Yes.
I will surrender and they will protect me in the lawyer, JMFC. Someone has been issued.
Who can stop you? Can do
No,
that.
see, sir, arrest, that is only.
Can I do?
Sir,
This court doesn't have jurisdiction.
sir, sir, ladies, final form, sir, police has already reported.
Why are you apprehensive? You may get the bail. What are the offenses now?
37 is, this 307 is there, but no medical evidence. Police also reported.
Where is 52? Item 52?
My lord.
Yes. Where is the medical evidence? Show me.
The medical evidence is not, my medical report is not there. Police has reported, so that is mentioned by the police, my lord, in the report itself. As page 27. Page 27. The lordship, last portion, my lord, the police has clearly mentioned there's the case has completed. There is no any evidence against any person in this case. Even medical report is not there, my lord. They have not sent to the.
In the petition is seeking the quashing of the cognizance order dated 19/3/2024, whereby the court below has taken cognizance for offence under section so. When consequently petitioner submits that after the investigation, the police had filed a closure report. Closure report on, where is that final form on 30 Bharat 2003. There was no injury report placed before the court as there was no injury sustained by the informant. However, the informant filed a protest petition. Protest petition.
IAC की कहीं पार्टी करछन्ती
Protest petition.
कहीं करछन्ती गोटा तो फिर थिबो ना प्रोटेस्ट पिटिशन रे आपण आछन्ती IAC की पार्टी करिवे
Informant. Cognizance has been taken. He submits that his client would be appearing before the court on or before 30th of June 2024 and seek remedy available to them under law. The consequent petitioner submits that lady member. How many petitioners are the? Where are the lady members?
Petition number 4.
Petition number 4 is the one is
Only one lady member.
Yes, sir.
Ladies, sir, ଘରେ ଶୋଇପାରୁନାହାନ୍ତି ଭଦ୍ରଲୋକ ଭାଇ ଗୁଡାକ ସାର୍ ଗୋଟେ ପରିବାରର ଲୋକ
Why are you?
ଏହା ଆଗରୁ ଦୁଇଟା କେସ୍ ଇନଫର୍ମାଣ୍ଟ ମାନଙ୍କ ଆପଣଙ୍କର
The opposite party number 3 is also a family member.
ସବୁ ସାର୍ ଏଣ୍ଟାର ଫ୍ୟାମିଲି ଗୋଟେ ପରିବାର ଲୋକ ସାର୍ ଏ ଯେ ଲେଡିଜ
Informant. Also related to injury. Nobody is under 307. I am not inclined to analyze the evidence that we say. However, liberty granted to new appropriate petitioner to new appropriate application. I have written.
Item number
Original certificate.
51.
Dispose of. Yes.
51.
51.
I was there, but the matter started taking a compromise matter. I thought it would take some time.
51 कौन है?
51 ना pass over करते हैं ना?
No.
What is this matter?
Well, it's a case rejecting my application under C11. Victim was examined as PW6. After her examination, well, an application was
that is POXO 33.5. How to get out of 33.5? 33.5 of POXO.
Cannot.
Well, with regards to recall.
There is a bar.
I don't know. I have not seen that.
You just take it up.
Well, day after tomorrow.
There is a legal bar that you can't
recall. If that is the legal bar, whether I have not
But
seen,
that will
I
not
have not yet
preclude you-
faced it. I'll see it today, day after.
Right. 54.
53. 53.
No,
53.
Yes, 53.
Yes.
Here, Your Lordship, even though the order of cognizance is challenge, Your Lordship, but the petitioner wants to bail, Your Lordship. Here the case, Your Lordship, they have been granted anticipated bail, page 40, Your Lordship, will have, and subject to verification of criminal antecedent and injury. And we filed the petition before the Lorraine trial court, and the trial court called for the injury report and antecedent report. During that period, Your Lordship, police submitted charge sheet adding 307 of IPC, Your Lordship. Initially, FIR registered under section 341, 323, 325, 34 IPC. But during that period, Your Lordship, 307
ଗ୍ରାଉଣ୍ଡରେ ତାଙ୍କୁ ଆଣ୍ଟିସିପେଟରୀ ବେଲ୍ ଦିଆଯାଇଥିଲା ଗୋଟେ ହେଲା ଯେ ଯଦି
injury ଆଉ antecedent.
ପ୍ରିଭିୟସ୍ ଇଞ୍ଜୁରୀ ଥିବ ତାହେଲେ ଦି ଅର୍ଡର ସାଲ୍ ନଟ୍ ବି ଗିଭେନ୍ ଇଫେକ୍ଟ
Again.
ଯଦି କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଥିବ the order shall not be given effect. The two
Okay.
condition was there.
Yes.
In trial court, they submitted that this is simple injury. So that is why court ordered that.
Yes.
And it was when the injury report and the antecedent was called for, he was having criminal antecedent. The injury is grievous. That is why the case was rejected.
Criminal antecedent.
ଆଜ୍ଞା
Court
antecedent କଥା କିନ୍ତୁ ଆମର ଅଛି ଏଠି grievous injuries.
No.
See, I'm
This
not
is
bothered
page
whether
27.
got the bail or not. 307 is invoked now.
Yes.
Earlier, this provision was not invoked.
My lords.
Now you use Sushila Devi and get out of it. What is the problem?
Lordship on that observation, Lordship.
No, no. ଏ କେସରେ ସୁଶୀଲା ଦେବୀ ହବନି କାରଣ ତାଙ୍କ କେସଟା ପରା ଆଲାଉ ହେଲାନି in view of the observation made by this honorable court.
The bail was not granted.
Bail,
Yes, yes, sir, Lord.
bail shall not be given
Why
effect.
don't you repeat the bail?
Yes, yes, that is the
438 you can repeat.
yes, that is.
Kindly.
I'll keep it pending. Go and I'll not pass any order. Go and file 438 because see, if you would have been granted the anticipatory bail and thereafter 307 would have been added.
Then Sushila Agarwal case.
Yes.
My lord.
Now in your case is your bail was granted to you subject to two conditions.
My lord.
First condition is you should not have any
Antecedent. We have no antecedent.
The second condition is the
Injury whether
grievous.
grievous.
Yes.
And it is found that grievous are
Yes, my lord.
you have
Lordship kind of plans on it. Yes, sir, Lordship. Kind of plans on injury report, Lordship, page 29. My lord. The injury report, Lordship, the one handle, Lordship.
Someone is to like that. Yes, yes,
All the agents except all of them are all of them. It is very
Well, examined as PDOL 1, but she is not coming forward for further cross-examination since 2017. Now, 7 years I am waiting for her further cross-examination.
Then I'll issue notice, call her. We'll see whether she's
Correct.
interested or not.
Correct.
Maybe she may not be interested.
Since it is a complaint case, the lawyer should have taken, but I am a ex-accountant general of Odisha. For this, I am not getting retirement benefit.
It is harassment in the work.
Yes. Clear case of harassment. My lord, no, starting from Menaka Gandhi case, Article 21 of the Constitution in India.
Let us see. I issue notice. Let us issue notice. Returnable immediately after vacation. Immediately 20th June. 20th, 21st quarter. Yes.
I have filed I also. Unnecessary hassle he appeared. If she is no more interested to proceed with the case, let it close here. So let me stay off.
Why you are grievance is she is not coming.
Yes, I have given the order sheet.
Why are you interested to stall the proceeding?
No, because
He may come with the next date of hearing.
that my lord, your lordship can enter order should have annex. That annex is 6 series. 6 series, your lordship can see page 69. First examination was 10/11/2017. My lord got it.
10/11/2017.
Yes, page 69.
Examine and cross-examine.
Yes. Your lordship can listen thereafter.
This PW1 is the informant.
The complainant herself. Thereafter, your lordship can see the entire order
Been
sheet.
examined and cross-examined.
Further cross-examination defer.
Right. Program then submits that on 10/11/2000 notice and 10/11/2017 the PW1 who is the informant in the present case, informant of the victim in the present case was examined and cross-examined and the matter was adjourned for further examination. Further cross-examination. Since then, the matter has been restated time to time. How many dates? How many dates we have gone? Let us see. That's 1, 2.
17 to 24 my lord indicate that from 17 to 2024.
7.
She is not turning up.
Net has been discharged more than 50 times between 2017 to 2024. But the victim of the informant is not appearing in the court. Not appearing in the court. Not appearing in the court. Therefore, it could be inferred that she is no more interested in the present case. In view thereof, the further proceeding in so and so district. Next. Yes.
No. Notice by registered postal.
57. Yes.
Then on behalf of Hon'Ble Ratna Panda, I may be permitted, my lord.
Yes.
My lord. My lord, the impugned order is at Annexure 3, page 36 for release of vehicle, my lord. The Honorable lower court has rejected this application on the ground that the ganja was transporting in the said vehicle, my lord. And the vehicle is in custody since my lord 21/7/2022, my lord. My lord, this Honorable Court was also directed in CRMC number 2924 of 2022. If the owner is an accused of the vehicle, if the owner is an accused of the said vehicle, then also the vehicle can also be released, my lord. In CLMC number 2924 of 2022, my lord. My lord, I am having in my mobile, my lord, sorry.
There are two applications before this, my lord. Two applications have already
You
been
have
filed.
the order.
I have only down.
You are citing some judgment.
My lord, I have mentioned in.
That's not reported judgment. Okay.
Yes.
You are seeing in the mobile. You say that you have it.
My lord, I am.
Give the mobile then. What can I do? It is not reported judgment. Where from I get it?
29.
No. This is not.
2924 of 2022.
Yes.
Sorry, this, my lord, this two applications, it's a case of 2002. Now we are in 2024. CRLMC number 2593 of 2022, it was dismissed on 6/2/2023. Why they have filed? They have not given. Then CRLMC 3236 of 2023.
What happened to
Due to non-appearance, dismissed, my lord, 3236.
Revive that. Why are you filing a fresh one?
After, my lord, some.
You are not sure about it. You will
My
end up, your mobile will be confiscated.
No, my lord.
And then you move another application.
After improvement of the case, we are filed this in the code below, my lord.
For the petitioner seeking an adjournment to file the additional document to substantiate his case and to clarify regarding the earlier proceeding he has drawn up in regard to the same issue. Adjournment. Yes.
तापर भी मैंने फाइल करना थी before the sessions court, before sessions court भी फाइल करना थी, right? SDM को order टाको आने की आसन. It's not a matter.
Yes. Next. 150.
Item 115.
115.
What do you call it?
115.
But I've got the full facts, not enough, it's kind enough to. Well, in this case.
Mr. Maharaj, you are supposed to.
Yes. Yes, I am
Got
ready.
it?
I am ready.
And the petitioner stays at Mumbai, at Bangalore, I'm sorry, Bangalore. He opened a wallet. We are something called a portal which facilitates transaction of various customers. We have large number of customers to provide them VDA, something called VDA, Visual Digital Assets. Virtual digital assets. He applied, gave 90,000 rupees from his bank, that is HDFC Bank, Mumbai. Am I correct?
Go on, happy.
Bangalore. And then that money came to me.
You can't disarm him like that.
No, I'm not that. I said it not. I find that one of the very sharpest. But I should say in all.
Very effective asset.
Very effective.
Very effective asset.
Very effective. But it's same like the Justice Nursing, who he was, who panned with So, but he transmitted a sum of ₹90,000 to us
Yes.
with an instruction that you kindly invest this amount in some other BDA. We have other BDA. Now, by that time, as per his instruction, we did it. After that, he suddenly writes again,
Yes.
no, I don't want there, I want somewhere else.
Yes.
I said, we have already transmitted. Manas Ranjan Mahapatra is the name complainant. Everything happened there. 90,000 is the amount involved. Admittedly, these are the admitted facts. Now, instead of 90,000, the IO possibly, I don't know, could be related to him. Because no cause of action is here. Bangalore is his bank is at Bangalore. I am at Mumbai. The entire transaction takes place outside of Odisha. But since maybe he knows this concerned IO, he tells bhai kuch
See,
karo.
where you stay, where you operate, nowadays doesn't
Nowadays,
matter.
you can find
Everything
zero
is
FIR and all
e-banking.
that. But then I am only saying for
We have to only see whether this seizure of your account
is proper or not.
related to some case or not.
That is the product, that is 102. That is the parameter of 102.
That is the sum total of my.
Some total of
Then-
summation
then-
that has to be seen
Then
when
perhaps the remedy is somewhere else.
correct.
Your Lordship, I can just say this.
Now,
Give it to
Sir.
account number. Is the first.
it is called coin, is complete. It is the complaint, sir? Okay, very well.
So,
So he admitted the amount of 90,000.
Amount of 90,000.
Amount. Thank you. One second.
If the fraudulent amount is deposited in your account, what to do? It is there.
It's there.
This is one, this second is one of preliminary stage. So we cannot access to that, whether it is actually what happened, whether that only.
How much time will you take to investigate and
No investigation.
Just initially.
Refer your lordship's kind attention to page 20. Para 20.
para 20?
Para 20.
Yes.
The amount is admitted INR 90,000. Okay, you keep that. You keep 1 lakh, defreeze 1 lakh. How I am supposed to give huge income tax, statutory dues, payment to my workers. Everything is told. Whole thing.
So
you take 2 lakhs.
So what is the procedure to that effect? Whether a person can come up before this honorable court challenging that only a online application, or he is to approach before the court below. Only 457 is required, my lord. This is not the application. Why this?
His entire bank account is freeze. Is there, what is the balance there now?
My lords, about 9 crores. 10 crores. 10 crores.
I think you have earned money.
Say it again. Only my submission only that level, because this is the one fraud amount. Whether the fraud amount exceeds, who can say? Neither me nor can the investigation officer, because it is only the investigation
I
says.
think my friend hasn't got it properly. Have to pay income tax. They scrutinize everything. It's not that I'm a fly-by-night operator. So therefore, at the moment, this is at an interim stage. You're
With all respect to my seniors, with all respect.
My suggestion is to your lordships to do justice to balance the equities.
Yes, that's
No,
what I'm
that-
saying. What way?
minus whatever amount your lordship feels may keep it frozen, modify this order, and the rest of the amount may be defrozen so that I can pay my statutory dues. And in the due course of the, because the notice, they will file a reply, the matter will go on. I'll file all the income tax returns, I undertake. Who is it? I'll file. To balance the equity, the lordship made 2 lakhs. 5 lakhs.
Sir, can they,
5 lakhs. All right, I leave it to the court.
how could-
I leave it to the honorable court.
Let the investigation progress. Let some to some.
For
extent.
90
This is the preliminary stage.
He says that 90 crores.
Yes, yes.
90 crores?
Yes.
90,000.
9
No.
crores. What is
Subject to
the
your
In the bank
commission.
account it is.
Maybe 9 crores.
Exactly, tell me.
987, I've said in the petition.
They should have very clear that these are our
5 crores.
5 crores.
5 crores, my lords.
Yes. Yes.
We don't know, sir. Give me the then your income tax. I will
Lord,
check,
kindly consider 50 lakhs.
50% of the back and subject to further verification for 6 months.
My lords,
For 6 months, I am saying for 6 months.
For 6 months. Yes.
For 6 months, let it be continued.
Yes.
After 6
my
months,
lords,
you will be.
my lords, may kindly, how can the inquiry continue? Inquiry, not investigation.
That's right. 6
So-
months, therefore.
My lords, I bow down. I'll give you the examples. For instance, in Prevention of Corruption Act, as per section 18, it is 2 months. Inquiry completion event. My lord, this Honorable Supreme Court, in exercise of powers for exercise.
The enormity of the allegations, we don't know. The length of investigation, we don't know.
We don't know.
It is very.
My lord, the investigation has not started.
Tomorrow, suppose I'll release 2 lakh rupees, you take away the money, and it was found that you are involved in.
My lords, may,
2 crores. What would be the result?
my lords may give whatever figure lordship feels, but according to me, Supreme Court has come down heavily on this practice. There are judgments of 3 other high courts.
Therefore, I'm saying 50% we will
My
operate.
lordship may reasonably make it down little.
You
For
tell me,
90,000.
you tell me,
Maybe my lords may make it 50 lakhs.
Your lordship rightly observed, your lordship rightly opined, and I don't have any objection to that respect.
Like,
But we,
and subject to, again, it is all subject to the
Yes.
investigation.
Outcome of investigation.
And you move application.
and for
For
a
variation
6
of
months,
that order.
I don't know,
No
6
problem
months.
is
6 months is a very long period. I am saying statutes.
Subject to conclusion of the preliminary inquiry
Yes.
within 3 months.
Yes.
3 months, 50%.
Amount I can take care of business, sir. There are so many customers.
It's very difficult in
Yeah.
this stage to assess.
Well, we have to return.
You can survive with 5 crores for 3 months. I am sure.
About what 1 crore kouchenti? 1 crore. All right.
Not
be able to function.
Not able to.
Not
But-
function.
We have to shut shop, your lordship, because we have to return to customers, and as soon as this money is of other customers.
See, I'll tell you, you have not placed anything on record.
anything, not a single
Everything
paper.
is speculation. Then I'm giving you 2 days, you place on record. I'll
You place all the records.
something has to be there.
File your-
Well, therefore, I am saying to balance the equities, your lordship may say 50 lakhs in case and make a conditional order. In case the IO finds anything, he is at liberty to seize the whole thing. Make a conditional order. Any amount.
No,
Give full-
outside of
give
money.
full liberty to the
This is
IO.
my submission. Nothing would be there.
Then it's very difficult.
Nothing would be there.
Very difficult.
It's a chirai property you're
I'll
talking.
pass a equitable order to suit both of you.
As your lordship pleases.
Well, not 5 crores. Please, I'm begging.
Let me see
Yeah, lordship may.
what best could be done. You have to.
The order has to be modified.
You should have filed something. on
And
the
whatever
court.
your lordship is going to pass, that is, my lord, I am always bow down my head before your lordship's consideration. Without a pen and paper, your lordship is going to pass the order. That is sufficient to the.
No,
petition.
it is there.
This is my submission.
Your lordship, the bank account is frozen without a notice to us also.
Nothing.
We are not able to even to approach the magistrate.
We have
You
approached.
show me that.
Here,
the
well, the bank has given a notice.
Bank has given the
Bank
notice
has given that. Last time your lordship said,
Yes.
get something from the bank. Bank has-
Where is the place those things on record?
Additional affidavit, please, it is-
Are you placing this thing on record?
Yes.
Place that on record.
Yes. Place 7 of the additional affidavit.
Yes, sir.
Very clearly bank has said.
Yes.
Obliged.
Yes, most obliged. 58.
Last report has been come from the police station. Whether that compromise has been affected or not, that reports para se has already come, your lordship. Here, parties has already appeared before your lordship.
ये तो कहने से फाइल तो रहबा किछ तो लोक ना लिखाई जात्रा compromise है ये
But last time when why you withdrawn?
yes that is why we suspect
When
that is
verification
why
was done and you withdraw. You created a doubt.
1 PM quick.
By that time, what happened? PC person of compromise petition was filed, but later on when it is came to our knowledge that no compromise is made, accordingly it is in Udri. Now, by that reflex of time, they have been regretted their incident and made compromise. Accordingly, filed this application for a passing your lordship. And now your lordship is taken instruction from
Now,
the
is it so?
yes
What is the offense?
3 ACS tag is there, 5 basis.
506 and
448 323 325 354 294 506 34 IPC and section 3 of the SST Act. Fine. I'm just verifying the accused persons. That.
No, you do.
Yes, ma'am.
Matter was taken up for hearing on 5/7/24. Okay. Following order. नहीं हाँ सरपंच following order सरपंच ने कोड ठीक है persons to the aforementioned direction a written instruction has been placed on record. Written instruction dated for those of Pan to be placed on record by Mr. Maharaja. Maharaja, we are speaking, we have confirmed the fact that the parties have settled there.
They have signed the report. They have signed
With your kindly, I'm sorry. Kindly give me liberty to file additional documents. My income tax that has to come in the order. So
that will be a source of arriving at a right.
no, but that's what I'm saying. I'm a little larger. No other high court. I've gone through Karnataka High Court, Telangana High Court, and all the judgments. I want to assist your lordship meaningfully so that a good judgment comes from our High Court as a pioneer High Court, comparing with Section 18 of the Prevention of Corruption Act, in which Supreme Court has said prevention of corruption, because I think your lordship has given 2-3 very good judgments.
Right.
The Prevention of Corruption Act, under Section 18, you cannot keep it more than 2 months.
You give a written submission along with the document so that I can.
Yes, even PMLA within 2 months, 60 days. So therefore, the 102 unbridled power given to the IO for any indefinite period, Supreme Court has come down heavily upon that. Those portions I will quote. So a pioneering judgment, my request is pioneering judgment should come from our court.
That will be a great thing if you assist.
I'll do that. I'll meaningfully assist, my lord.
That will help.
And my friends should also
And he'll also do it.
assisting the court so that we come to a meaningful
Lay down the law, the scope
Lay
of
down the law.
102 vis-a-vis the special provision under Section 18 and
which are much more stringent. Those statutes are much more stringent.
After that, many decision has come up. Lord. After that,
you just give
Because immovable property, Supreme Court has struck down. 3 judges of the Supreme Court have said immovable property you cannot attach under 102.
that is a separate procedure because Section 18.
102.
No,
I know
what
that.
he's saying is he will be giving a written submission and you also give. Let us see if any good judgment.
In a
will come out.
stringent statute like PMLA, stringent statute like Prevention of Corruption Act.
Sir, what you do is you written submission, please give in advance to him. So
I will
that
do
he'll
it.
deal with it.
I'll do that. Great.
He will give in advance to you.
Great.
Yes.
Sushant Kumar Sahu, office number 2 years.
OP number 2.
Yes.
And 3 and 4.
3 is the for
Pramod Sahu,
son and daughter.
Injured.
Son and daughter. अच्छा पंचू बेहरा
Police party number 2. FIR
जो रंजन कुमार बेहरा
came to be registered against the petition.
भारती बेहरा
After investigation, charge sheet was filed. Charge sheet was filed against the petitioners. On the charge sheet was filed about
12/9/22.
on 12/9/2010. Cognizance has been taken.
Yes.
Yes, ma'am. For that, okay.
And cognizance for offense under section section 448, 323, 525, 354, 294, 506, 34 IPC, read with section 3 of it taken against the petition.
This is the cognizance order if you also wanted to then.
Cognizance order office would have to be taken. I think how it has by the order number. Again, when the matter stood thus, parties have settled their dispute. dispute. The petitioners and opposite party number 2, 3, and 4 are present in the court. Opposite party number 3 and 4 are the victims, are the injured. Presently, those who have sustained simply injuries. Parties have the petitioners and the opposite parties are represented through their respective counsel and identified. They've also filed self-attested copies for their Aadhaar card with submit their identity, which are taken on the record. Affidavit.
Affidavit is
the opposite party number opposite party number 2, 3, and 4 have filed dated 7/5/2024 stating that they were settling the dispute on the intervention of the village entry and well-wisher. So as to maintain peace and tranquility and brotherhood in the area. They don't want to proceed against the petitioners. Maharaja, a for the state will submit that the act of settlement has already been verified, and the IIT PS has given a report entirely stating that parties have indeed settled the dispute in order on the intervention of the elders and well-wishers. That I have well-wished. In view of the aforementioned, there is no legal impediment in quashing the FIR, taking into granting and so on so it's quashed. How much pay?
ଘର ଚାଳକୁ ଚାଳ ଲାଗିଯାଏ
ଚାଳକୁ ଚାଳ ଲାଗି ଥାଉଛି ପଇସା କେତେ ଦେବେ? You have wasted twice. First you came, wasted the court's time. 5 ଜଣ ଅଛନ୍ତି 5,000 ଦେବେ 5,000.
ଗରିବ ଲୋକ ଆଇଲେ ଚାଷ କରିକି ଚଳନ୍ତି ଡେଲି ମଜୁରୀ ଲାଗନ୍ତି
2,000 to the bar, 3,000 to the. Three respondents are there. 3 opposite. Give 1,000 to them and 2,000 to the bar.
Yes. And consecutive orders are there and may
ଗଲା ମୁଁ ମେନସନ କରିକି ବସି
Man, how can I make him wait? A small matter, only it's compromise.
Compromise.
I had mentioned,
whether in this matter the other side is ready.
Item 123.
1 minute.
Two.
137.
137 to 142.
142. Who is appealing to the other side?
137 to 142.
Your Lordship, may I mention item 108?
1 minute.
Please, Your Lordship.
Yes. Who is appearing for 137? Let us just, then I'll take it up. 137. Show in the board. 137 so that somebody will come. Yes. 123. 123.
Both the matters have been clubbed out together.
123.
Yes.
Yes.
Well, both these matters arise out of. May I submit my list?
Yes.
Both these matters arise out of a common affair based on a private complaint.
Yes.
And the short background factor is that the complainant, the opposite party, was, and in fact is continuing as the agency of Matrimonial Education Publishers of India. And he first, the complainant, now who is the complainant as power of attorney holder of his wife? He was originally he was the agency holder, and thereafter, after 2 years, 2019, thereafter he wins his interest that he will quit and his wife will be the proprietor and all that. So she continued. And they had given a check, security check of 10 lakhs rupees. In the event, they failed to pay the book sale value, that will be utilized.
So what do you want then? Now you are...
Ma'am, both the parties, it's a private complaint, both of them have compromised together.
And I
they,
issue notice, let them come.
Serial number 387 for 2022.
Yes.
There, my lord, return, my lord, undelivered.
That is.
When nobody is appealing, how can the case will pass, my lord?
You take press notice. I mean, the first item I will issue notice. In the second item,
somebody appeared. Sunil Patnaik already appeared.
State कौन करियो अपन? Both the complainant himself has filed the complaint in both the cases. Both
right, but somebody has to be there.
That is unfortunate for me.
On
They have already filed, and in the meantime, also that 138. This all crept up from 138 petition NI Act filed by the company, my company.
Shall I send both the matters to mediation?
Pardon?
Both the matters, shall I send it to mediation?
May I pray, man?
Or otherwise call the other side. Let the parties.
Let the matter come on Thursday, my lord, on 16. To be taken over 2 o'clock, so that I will ask the other side.
Thursday it may not be possible, sir.
So Friday, my lord. Any day convenient to my lord before vacation, that is on Monday. Let it be on Monday.
Monday.
କୋଉ ଦିନ ଦେବେ ଦିଅନ୍ତୁ ଆପଣ
21st.
21st. To be taken about 2 o'clock, so that they will know that the matter is to be taken about 2 o'clock. Oblige, madam.
Somebody was mentioning. Yes,
Your Lordship, item 108.
Yes.
Please, Your Lordship. Item 108. Your Lordship, we are being led by Mr. Siddharth Luthra, Senior Advocate from Delhi. We were requesting if a short accommodation for this Wednesday, that is 15th at 2 p.m. can be given.
This Wednesday, it may not be possible because, see, even if it is listed, it may not reach. That's the difficulty.
If Your Lordship would put it at 2 p.m., I'll be deeply obliged.
2 p.m. also, just see, the board is very heavy. Friday, let us see. Put it on Friday, we'll see if possible.
Would Your Lordship keep it at 2 p.m.?
Yes.
Friday at 2 p.m.
Yes.
I'm DPO.
Item number 65.
Wait, I'll take it up. All the matters I'll take it. Yes. 137. Yes.
I'm filing an application for quashing the complaint.
Yes.
And the complaint arises out of an assessment order.
You are from solicitor's office? No. Who is from solicitor? Just call solicitor.
21. Please suggest it.
So that I can hear it and finish up.
My lord, I am sorry, my lord. I'm held up, my lord.
Yes, yes.
What I'm praying, my lord, this Sirajuddin case is fixed to today. I am seeking time, my lord, because we have to file because this document basing on which cognizance has been taken, neither the petitioner has annexed it nor we have filed the counter. So we will file the counter within 7 days. Let's may keep it to after vacation.
I am not relying on any document.
He says that he is not relying upon any document.
But it is a very important document which is required to be put forth by lord. Without perusing the same, proper education cannot be made because the cognizance has been taken basing on our document. We have to rely upon the court, my lord.
Okay, your documents you were filed. I will give a copy to you today.
That's why I'm saying this the document is with us. They are praying for 15 days and 2 weeks time. With the file all the documents with affidavit. Then lordship may finally hear it. There is no. So after vacation, any date lordship may fix if my learned senior will.
Monday, I don't know whether it will reach or not.
Let us see on Monday 2 p.m. If it doesn't, it doesn't.
After vacation, it is better. After vacation, any date, let's say fix. After 20th of June, any date, let's say fix.
Last time also.
See, Monday we
open on 18th.
Monday, let us take a chance on Monday. If it happens. If it doesn't happen, then
but
we'll go
by Monday, I could not file this petition. That's why.
But what he says that he will supply the copy. He will file the document.
And he will file the document, but simultaneously we have to file so this document along with other document by way of affidavit. Let's me keep it Monday. We will try our best to correct. Otherwise, let's me.
Okay, Monday.
137 to 140.
137 to 140. Interim to continue. Yes.
All the 6 years, am I?
Yes. And he'll supply the documents. And rather he'll file it also.
Yes.
If any additional document you want to file, meanwhile you file so that we will see on 20th.
I'll try my best to file it. If possible, we definitely will file.
Yes.
Obliged.
Come to the list. Yes.
We'll pass on a slip. Yes.
Yes. Yes. Which item? Item 22, madam. 22. Yes. 2. Offense
143. 143, madam. 143, madam.
Sorry. 143. Yes.
I mentioned my lord one important. Yes, my lord. Passing of criminal proceeding.
Which one?
143, my lord.
Yes. 143.
Here, my lord, notice has been issued to the informant victim, but nobody has appeared. As per the list, my lord, cause list, my lord. Here, my lord, passing of criminal proceeding, your lordship kindly have a glance to the FIR. The offense is not made out. Your lordship kindly come to page 11, my lord.
143.
Here, your lordships had also called for the case diary. I had spoken to the IIC today morning. Today, Karandi has elections.
Neither case diary then there nor the informant there. Notice was issued. Let it be listed sometime.
So, may I pray one thing? I have also filed a IA, your lordship may kindly consider it, my lord.
IA last time I didn't consider means there must not be anything. Anyway, let us see what.
No, it has been adjourned that somebody will appear late. That is why your lordship has adjourned to today, my lord. Now, my lord, as for my lord friend's submission, my lord, now the case diary will be produced before your lordship.
You move an application there in trial court.
No, here, my lord, I am for the questioning of the FIR, my lord. So now the case is.
What is the stage?
Investigation stage, my lord.
So then
he has not been arrested yet.
Huh?
He has not been arrested.
Then I can't pass in anticipatory bail.
No anticipatory. I am not
paying
for
investigation is going on. I can't say anything.
No, I am not paying for stay of the investigation, my lord. No coercive action, my lord. I will appear before the IO as when directed. I will cooperate with the investigation.
That is what is the bail.
No, that is not bail, my lord. That is not bail, my lord. If your lordship can have a glass to page 11, at a moment, your lordship, if the offense is made out on the trace of the FIR.
I don't know, investigation is still on. How will it help you?
Because, my lord, here the victim is the informant. No more things will be come during the investigation. Here the informant is the victim.
If you have read fodder scam matter?
My lord.
Who was
No, I have not gone through that matter, my lord.
Because the complainant become accused and he became convicted, confirmed by Supreme Court.
But that is a separate thing, my
The
lord.
investigation-
That is a separate thing here. Here, my lord, the informant is the victim.
it is a
He-
threshold at this
on the
threshold.
face of on the face of the complaint, my lord, the offense is not made out. Your lordship, page 11, your lordship, can I last?
You keep it on 21st. Get it, huh?
Yes, sir.
Election is there, huh? 21st.
Obligation.
Next.
Item 6.
Six.
Compromise matter.
Yes.
That my lord has said what is
Previous signature.
Got from the.
Constructor କିଛି ନାହିଁ କିନ୍ତୁ ଅଲଗା ଅଛି ଗୋଟେ
That is
exact ନାହିଁ grievous in nature. No.
You given that. Which paragraph?
First paragraph first, on the basis of the compromise in the on the basis of compromise by 13 entered into and between the parties of the accused in the affair and the respondent note, the High Court has refused to exercise the extraordinary direction invoking the provision of the on the ground that 4 injuries were suffered by the complainant, and as per the opinion of the doctor, injury number 3 were very serious in nature, my lord. Then page 4, my lord. Paragraph 4, para 4, para 1, para 4. Last 4 line.
Injury number 1 to 3 are the sharp weapons. Injury number 4 is simply on the statement of injured.
That's it, very good.
Ultimately, what happened in this case?
Para 34 and 35 was last page 14, 34 and 35.
Yes.
So here, my lord, what happened? Only gunshot injury there, my lord. We have to ascertain whether the accused, my lord, any criminal antecedent or not. That is the question, my lord. If he has having been so, that cannot be.
I'm not just.
You should be ready with all these things. These are serious offenses. If you want intelligence of this court, you must be ready with all facts.
Sorry, my lord, but
No antecedent, then my lord, second thing.
If you have antecedent 307, gunshot injury, grievous injury, and you want intelligence of this court,
Here is the case, my lord.
at least tell me whether you have antecedent or not.
There are 5 accused persons, my lord, so individually I have to go through.
Obviously.
Obviously.
Then we will put them to terms. I fix it and e-judgment document fix it immediately after this. 20th.
Before vacation,
Immediately after vacation I am putting.
This is one of the co-accused, my lord.
Arms acts offenses. One of them is absconded and it is a gunshot injury. I'll quash it, but at least you assist me so that
Yes,
I
my
can,
lord.
do it. Wait,
15.
15.
Hearing discussed, my lord, the recall petition filed by the petitioner has been rejected, my lord. Because the PW1 is examined, my kindly see page 5, annex of 1 in para 2, on the date the PW1 was present before this honorable court, and due to engagement before higher forum, the appointment
lawyer could not said PW1 could not be cross-examined. If the said PW1 will not be cross-examined, the opposite parties are supplied.
Where is the
My lord,
evidence copy has not been filed? You have not filed anything.
And that one he has examined in the year 2017.
And what is, where are the evidence?
Questionnaire is also not given.
Questionnaire is not there, evidence is not there, you have not filed anything.
Evidence for that.
Doodling some one-line application.
what he has given that I have produced before your lordship.
But where is the statement of the PW?
And produced application.
Let us convert the petition requirement to file the additional document to substantiate the case. Matter is judgment. Yes, next.
Much obliged.
22.
Yes.
The last one direction to the informant and victim to appear.
Simple injury.
My lord, simple
Injury
injury.
is simple.
My lord.
Show me the injury report.
My lord. The injury report.
Injury report. Where are they? Narayan Chau?
Yes, sir.
Where is he? Vishnu Chau?
Vishnu Chau.
Srimati Chai Chau?
My lord, we have
On this, also this simple application. Court to the
Where does it say simple?
also did it.
Party number 2. Registered against the
You are absent and the mother is present.
Where is the injured?
Out of session.
Tomorrow, if he will come and say that I have not told my wife, mother to.
My lord, in the deposition also, my lord, there's compromise, my lord. Your lordship, go to deposition.
Where is that?
My lord. My lord, your lord.
Everything you will keep it in your pocket. When I asked, take out one thing and give it. Place it on record. Yes. Is the injured, na? Injured is not made even a party. Nobody in the earth can help you. That's the whole difficulty. You create so much a problem for yourself. Injured is not made a party. 307. Causing the.
This one, I am.
Why are you creating problem for your client?
Sorry.
You implicate the party and.
I am appearing for.
You may appear, sir. Where is the party?
Informant.
I don't know. These are minimum things.
Yes, I have on the.
There's very minimum thing.
Yes.
Do you need to be educated in this?
Yes, sir. I am only doing.
Why are you wasting time? Your time, court's time, and the time of many lawyers. Do it after vacation. Then consider the petition to include the injured of the case, the opposite party number 3. He made also during the course of the opposite party. Yes. Implead right now and issue note.
They want in the personal appearance of the old lady and of the.
What is this? 52. What is the age of this lady?
58.
Huh?
58.
58.
Oh, none of them are old. Let them come. Next.
59.
50, 58, 60 year is no old. Let them come. And this has been created by you only. You should have completed the petition. Wasting time unnecessary. Next.
59.
Yes.
The petitioner is the husband.
Use the mic, sir.
The petitioner is the husband
Yes.
and wife is the infant. Wife filed an application against the husband before the IAC because of one dispute between the husband and wife. The khara chuti re wife is the teacher. When he left to the house of
It is a 498 case.
400, my lord.
Where is the
Your lordship can have a FIR. FIR
forget about FIR. Where is the lady? He's not a party.
Sorry, I may permit my life. Sorry, my. Sorry, but I may permit.
I don't know.
Sorry, I may permit, but I will impress you. And I want to, and I
Isn't
want,
it?
and I want to take.
Put it straight. You are wasting time on it. Isn't it?
60. I want to, madam, I want to take notice on wife.
If he's not a party, how will I issue notice?
Just.
No, do it. Don't waste time.
It may
Leniency doesn't mean that you will take everything granted. You are wasting time of so many people. Do you realize it? 150 matters are there. If you do like this, who will help you?
It may plead my lord. 60. The petitioner is a 70 years.
I record the 15 years. To plead the informant by the opposite party number 2. Let him do so during the course of the and issue notice. 60 years.
My lord, the petitioner is a 70 years old lady, unmarried lady.
Yes, sir.
And she's staying away from his brother. They are separated from brother. Brother was additional Tahsildar in state of Odisha in Tangrapalli.
Yes.
And vigilance raid was done, conducted in the house of her brother. And there was a disproportionate asset according to the vigilance.
What do you want in this petition?
I am not an accurate. My bank accounts have been seized. 9 bank accounts. No money is there. They have been seized. I am an old lady. I have to sustain my livelihood. I
No
have
money there. You are old. You don't need.
the 1 lakh or 70,000.
You said no money?
No, only one account. That 1 lakh is there, my lord. I have to take medicine.
How many accounts are
there? 9 accounts I have given at page 6.
9 account you have.
Yes, my lord. I am giving para 7, my
You
lord.
are old. You are not working. 9 account.
I have landed property. I have money
Why do you
from
have 9
cultivation. 9 account is there at the since my father was alive. Their account. My lord, I am giving.
Must be helping your brother.
My lord, no. In one account 7,727. In another account 7,372. 7,372. One account, my lord, 1 lakh. Let me complete, my lord.
I understood. 7 accounts. Seize.
See, I am not an
brother of a.
my lord, I am not an accused. My submission is I am not an
I
accused.
understood, sir. You are not an accused. Your brother is accused. He is held up in a vigilance case.
Vigilance.
Your account is seized.
Seized.
That's all. Right.
And seized, my lord, they have not followed section 18A of the PC Act.
So far as this petition is concerned, prayer is concerned, he has prayed for release of her bank account and account of his dead father and daughter, which cannot be because the account of other person cannot release.
Only that is only my account, my lord. That
Then,
so
far as
You have written his father, minor daughter.
no, my lord, that is
another
wrongly
aspect is
wrong.
he has approached directly under section 482 of the CrPC for releasing of the accounts, which is not maintainable in view of the recent judgment of the Hon'Ble Apex Court. He has to approach under section 457 before the lower court.
I am not an accused there, my lord.
Maybe.
I am not an accused there.
You can go.
Man, 482, your lordship has decided, this court has decided in a case, and my lordship was the conducting
And another
counsel.
aspect is,
Your lordship kindly see
that is in respect of 18A is means for attachment and confiscation. We have seized it. There is no bar under section 102 for seizure. That
Your
is in
lordship
respect
kindly
of seizing.
But directly,
And your lordship kindly see the document he has read.
that my lordship was the conducting counsel in this.
ମନା କରୁଛି କି ବର୍ତ୍ତମାନ ସୁପ୍ରିମ କୋର୍ଟ
Directly 482 ରେ release ହବା ପାଇଁ, I am not an accused.
this recent judgment
I have
that is I'm giving
You have that.
that is 2024 live law.
No, 24 live law. Yes.
Live law, Supreme Court
Why
289.
don't you withdraw and go to trial court?
Well, I am not an accused there, my lord, in that
And another
procedure. I
aspect
am
of
not
lordship
an
can
accused.
see.
24?
If I had been accused,
2024 live law, Supreme Court 289. That is
I am not an accused.
What does it say?
Khengara Bhai, Lakha Bhai, Dambala versus State of Gujarat.
What does
They are said without when there is a provision under section 457 CrPC, directly under section 226 or 247 to 482, they can approach directly for releasing of the property.
If he
See,
had, my
in
lord,
an
if he or she
case.
had been accused in that
And
case,
another
the
aspect
fact
is-
is completely different here.
Another aspect is, your lordship kindly the
Even if
document.
you are not accused, you can move application free.
My lord, the 482, I think, I will distinguish that
And
case,
your
my
lordship
lord,
kindly
to
see
your lordship.
the page
I will
23.
take the decision.
Page 23, your lordship kindly.
I have given a decision, my lord, to your lordship.
But sir, that decision is in respect, that is the fact of the case is different. Your lordship
Yeah,
kindly see.
different is, I am not an accused, therefore I should not go to that lower court, my lord.
Your lordship kindly
So
see.
that, I will give the decision on that.
23.
Investigation is still on.
Still on.
Still on.
23, your lordship kindly see.
So don't say that you are not an accused.
I am not accused, they say,
In FIR, it was not accused.
Yeah, FIR, they have not,
What's it?
Investigation, you may be an accused. How do you know?
By this process, you will be
there is
They
no
may invoke
money.
109.
There is no money in my account, only in
That's
one
it,
account,
because
1 lakh
don't
3.
make a statement that you are not an accused. 109 they can invoke and make you an accused. How do you know?
Now, at present, I am not an accused.
That is why you better than.
And I have no money, my brother's money
At
is not
present,
there.
I will not interfere there.
I will cite some decision by lordship.
But because investigation is still going on.
There were another aspect, page 23.
And my account may be only one account, maybe 1 lakh 3,000 is there. I will sustain my
There
livelihood.
the SP,
I am
you also got it.
separated from my brother.
23, yes.
Last para. There SP directed the IO to follow 18A. 18A for the purpose of attachment and confiscation. We are at the stage of seizure. That for the purpose is we have to confiscate.
Yes,
The
my
purpose will be defeated.
My lord, your lordship kindly see 18A, my lord. 18A, my lord, I am placing.
18A.
Yes, I will let me place. Same as other is provided under Prevention of Money Laundering Act, the provision of criminal amendment ordinance 38 of 49 of 44 shall as far as may be applied for the attachment, administration, attached property, the execution, order, attachment or confiscation of
Attachment and confiscation.
They have attached.
Not on attachment or confiscation.
I think this petition is premature. You wait, you have to wait. Investigation is still
My
long.
lord, I have given that judgment of recent judgment of this honorable court, my lord, I have given a copy. And your lordship's another judgment of honorable Supreme Court I am giving to your lordship.
But at the time of investigation also, one can do it.
That is during investigation. Here, my lord, the Vigilance department
ସେଥିରେ
are not concluding the investigation for years together, my lord. Even
When
till
is
10
the
years.
FIR? When is the FIR here?
FIR is
What is the stage of investigation?
that is the
2022, 2 years ଗଲାଣି.
2 years con 22 no 2022.
2022 near about 2 years.
And it's a DA case.
Disproportion near about 2 years. If in a disproportionate case, investigation has been going on for 2 years, my lord, near 2 years, my lord. Then when they will conclude the investigation?
They are relying perhaps that Ratan Babulal Lat case.
Yes.
In this case, they have employed 102.
Yes, my lord. They have, yes, 102.
102.
He is relying upon this judgment. This judgment will not help you.
The Babulal Ratan Lal, my lord.
that is
18A
the
has not been
attachment.
followed. 18 has not, A has not been.
Wait, I am simply adjourning it. Let us see.
Yes, your lordship kindly adjourn it, I will cite out.
You get the instruction.
Yes, all the distance I will say, and the recent distance which my lord and friend is citing, I will distinguish that distance.
Look into this judgment.
Yes.
And that, with all respect of that, senior counsel was arguing that matter. That is in 18 years, Honorable Supreme Court has a 2 month, more than 2 months, that cannot be. See, that is not the correct position of it. That is the wrong interpretation.
Give some judgment.
No, there is the statute says Criminal Law Ordinance Act section 3 रे ସେମାନେ approach करिवे add interim urgent attachment order will be passed. That is remain for 2 months. तापर सेटा final हबो. किंतु they are not in the stage of attachment or confiscation. That
attachment.
You tell that to.
I already have told it. And 457 direct आसी परिवे 482 रे.
That we will have to look.
My lord, I will cite all the distance.
Yes, next.
61. Answer 3. That is
8 years lady, my lord. She has in bail, my lord. She has a charge sheet on 490 for 507 for DP Act 61. For DP Act, my lord. And he has been bail, my lord, before charge sheet, my lord. After that, he has issued summon to for appearance. Due to the petitioner is the old lady, 80 years, my lord.
Yes.
She is bedridden.
Procedure କେମିତି କଣ୍ଟିନ୍ୟୁ ହବ? Procedure ଆପଣ ବେଲ ବଣ୍ଡଟା କଣ୍ଟିନ୍ୟୁ ହବନି କେମିତି ହବ? Procedure ଟା ଅଛି।
ଗୋଟେ ଥର appealing
My lord, he is the bedridden. He is the bedridden, my lord.
bedridden.
Bedridden.
I'll take instruction.
Yes, take instruction. Whether it is bedridden.
What is the offense?
What is the 490 for DP Act? 506 for DP Act. Present mother-in-law. I have yet as you go into the hospital treatment. I call you make ambulance.
Watching of the entire FIR.
Yes. Passing.
And he says I
Passing
for passing.
How the matter will lordship will quash there is the investor charge in file, my lord.
80-year-old lady and 498. What is this?
Charge sheet has been submitted.
Procedure ଟାକୁ
You are ill-advised to move this application under 205. Instead of that, you should have asked for quashing. You would have quashed it.
Then a
80-year-old.
lordship modulate my prayer or
File it Monday. I'll take it. You file a fresh petition. Monday.
Okay.
Mention. 80-year-old women and 498. What is this?
These are bar affair.
You file a quashing petition and mention and issue notice and quash it. Give advance copy to him. Yes.
62.
The Belgium matter, the petitioner was on bail, dated 13
Belgium,
2020.
Speak little louder, sir.
Recently,
The Belgium matter.
Supreme Court has held that exemption from personal appearance be granted prior to obtaining bail. Recently.
Forget about that. See,
No, no,
80-year-old woman and unnecessary.
205 ଟା ଅଲଗା
ଜେଲ ରେ ସେ ଅଛନ୍ତି ବର୍ତ୍ତମାନ ତାଙ୍କର
Bail bond ଦେଇନାହାନ୍ତି।
Yes, to appear, sir.
Bail bond
Yes, to appear.
ସେଇଟା ନ ରହିଲେ କେମିତି ହବ? Procedure ଟା କଟୁଥିବ।
He is ill-advised to file this. Quashing file. Yes.
My lord, quashing of NBW, the petitioner
You are
was on
bail?
bail. Yes, my lord. So dated 13/2/2020.
Yes.
NBW was issued on 25/8/2023.
500. Yes.
63.
May please your lordship. By the annexure 3, my lord, that is the order of the sub-collector regarding 144 proceeding in order to remove the passes from in front of my house to obtain ingress and outgress. That order is passed on 19/3/2024. Till now, that has not been carried out. But it is the instruction of my client.
The order last page, last page. Annex last page. Sub-parameter, I'm just reading the concern IAC. That's what it, the concern IAC.
Where are you reading?
Co paragraph problem.
To the members of a second party.
Which page?
Last page, my lord.
Oh, last.
Not mark the page. Last page, last page.
Last page of this petition.
Annexes.
Annexes.
Yes.
Yes. 14. Page 14. Notice. Notice.
To the members of second party, last word. To the members of black and letter to the members of second party.
You read it.
Yes. Then the next matter. I therefore hereby order. That's what it. Just below the
Under section 144.
Yes, yes.
CrPC.
Just next matter.
That is
The
member.
IAC is directed have a strict look out over the disputes and reported accordingly. ये report से दिल्ली की न देले report सेफ्टी करिवे ना एटी करिवे
No, no.
for it कौन
That the last order position, what the order position says that I therefore hereby order under section 144 CrPC that the member of the second party are directed to file show cause and they are restrained to enter upon the disputed land. The IIC Binjarpur is directed to take necessary step to clear the passage of the first party immediately. So as
He has sought for report.
in a report, yes, my lord, he has sought for report, but my submission is that whether my ingress and outgress
is secured or not.
Where is the report showing?
That report,
That report.
the date is fixed for the report. So also immediate step to be taken to remove the passage from improper.
How do you know it is, report is not there?
The order itself says.
No.
More gotte kali prayer gotte application apni just go and file an application against the IAC that he is not complying. Then you come up.
Then the counsel for the petitioner seeks to withdraw this petition to approach the executive magistrate Jajpur by moving appropriate application, raising all the points as raised in the present petition. You will see what is petition is put up. You move this petition, whatever point you have raised, the same application you move there.
Yes.
Before this approach.
Before the executive magistrate, if such application is moved, the same shall be considered on its own.
Stipulated period may be fixed for disposal of the same.
The same shall be considered within 15 days. Let it be 15 days. Yes.
Well,
Yes. By the time report might have come out. March Masar report. Yes. Next.
64.
More.
Yes.
It's praying for quashing of the proceedings, my lords, on the ground of compromise, my lords. Case of eve teasing, my lords. Okay, lords.
Appearing for the victim role and as well as the father in-laws.
The parties have come.
Plus the parties have come, because I am giving an affidavit as well as my Wakalatnama, Millards.
Give bring the party. Party. Who are they? Babulal God, Akshay, Amiya.
The first two petitioners, my lord, petitioner number 1 and 2 are there, physically present. The 3 is probably, my lords, online. High in the.
And what about Sudarshan?
Sudarshan.
Party number. Opposite party number 2. It is stated that the parties have settled their dispute. They are staying together.
No, my lord, they are separate things.
The dispute is arising out of matrimonial discord, and then counsel for the petition submits that the parties have settled their dispute. I issue notice to take.
17. 16. Yes.
66.
May I please? On the last occasion, your lordship has directed state to obtain instruction regarding the status of the minor child. As per my instruction, my lord, on 10th of May, IAC along with the petitioners went to the ashram and found that the minor daughter is adopted to another person. My lord.
Yes, sir.
What is this case is about? I
Yes, sir.
just forgot.
I have a question, sir. One child, a minor child, is 2 years, 2 months. It is alleged that she has been kidnapped. And if I register, investigation commenced. During course of investigation, CWC filed an application that who will take care of the 2 months child. That is why application was filed. It was given today that first home, the child was taken care of this first home. Thereafter, the application was filed before the family court. Now that family court directed by this to the CWC to give hand over to the a person who is adopting the child who will take care of him. Accordingly, a person that name has been mentioned in the instruction, they have taken care and they have adopted the child. But subsequently, after that, during course of trial, this petitioner find that they are not actually in fact liable for section 363. And the learned SDM directed the IU to hand over the child to the adopted father. But by the time that has already been complied by the judge family court.
Some other parents have taken.
Say 2 months dayitu ke na that I'll say order in 2021.
Now he is asking for what?
See, question say ebe jo exigent direction deji.
You hand over the child to the
can't be complied. The child has been adopted by some other
That
parent.
is the instruction I had.
You withdraw it. Now, since the child has already been adopted by some other parent,
Original instruction I am giving.
so you can't display the child. You can't display. ಈ instruction ಎತ್ತೆ ಬಿಡು.
ଆଜ୍ଞା two page instruction ଆଉ ସବୁ document ଯୋଉଟା ଆମେ annex କରୁଛୁ କୋଉ time ରେ କଣ ହେଲା that all these documents have been annexed in the instruction. The date has been mentioned clearly.
Yes, sir.
But during pendency of the trial, my lord, they have
Whatever. Now the child is
material saying that କୋଉଟା କୋଉଟା ରଖାଯିବ
paramount consideration is the welfare of the child. You have left the child in lurch. So somehow somebody came forward and adopted. The child is in the custody of some
child has been, my lord, seized from the petitioners. With an allegation that
କିନ୍ତୁ ସେ ଛୁଆର ଦାୟିତ୍ୱ କିଏ ନବ ସେଇ ଟାଇମରେ ତ କାହାକୁ ତ ଦିଆଯିବ ତେଣୁ
you are not the biological parent.
No,
my lord. Adoptive parents.
You are adoptive parent. Somebody else has adopted. Forget it. You have other options. You can adopt someone else. Why to displace that child? You are not the biological parents. You don't have a superior claim.
Yes. Had it been a case of a
Don't precipitate it unnecessarily. Don't invite some order and it's not in a good place. The child is already adopted and must be happily staying there. You asked the IAC, has he gone to the newly adopted child and had seen it? तुम्हारा बॉयस कहते बोलो whether that child is happy there. Adopted when? These new parents adopted?
21. 2021.
It's 21 to 24. She must be comfortably staying there, small child. Why to displace her?
Responsible.
That apart from technicality, see the position of the child. She must be there comfortably with her. Due to I will not record anything. Simply withdraw. Simply withdraw. In view of the development which has taken place in between, which is reflecting in the instructions submitted, the written instructions submitted to court, written instructions to taken on the court. Then content for the petitioner doesn't want to face this. Yes.
67.
May I plead your worship? The petitioner been implicated in a disproportionate asset case in the year 2015, your lordship.
Yes.
I have filed some documents before the investigating officer, your lordship. That was not taken care of. Though I have sent those documents, it's a lease agreement under Annexure 2, your lordship.
Charge sheet is filed.
Charge sheet not yet filed, your
Then how do you know? They will not consider or consider.
They're not taking that documents. Though that document,
they have to tell you that yes, we are taking. Let them file the charge sheet. They might have.
In the seizure list, they have not mentioned that, your lordship. Your lordship.
I don't know what is the worth of your documents.
Lordship may peruse page 9, your lord. The FIR itself. FIR itself, your lordship. Page 9.
Yes, he is giving some representation.
Documents means he is giving a lease deed executed by notary public, stating that an investigation says otherwise. And he is saying that your lordship kindly prayer direct the opposite party to accept that document and exclude that the same from the asset list.
Those things can't be done by.
Can direction be given under section 480?
I can't guide the investigating agency.
Let them accept my document, your lordship.
And
they're not accepted.
And we are also considering his document and examining the same.
No, they're
investigating the same. He is not cooperating.
That's all.
Your lordship may peruse page 9, your lordship.
That is the FIR.
FIR. They have mentioned about the documents, but they're not seized that. Though
how will they conduct investigation? I am not here to guide you.
Your lordship.
Your grievance is you had some document, you wanted to place it.
Lordship may peruse.
I'll record a statement that all the document which you will place will be considered.
will consider in accordance with the law, subject to petitioner is cooperate. Petitioner is not cooperating. And we
Similar-
cannot,
similar-
the other part of the direction cannot be given.
Yes, Lordship, in the similar case,
Powder.
I would take case.
ଆଉ ଗୋଟେ case ରେ କଣ ଏମିତି?
Oh, so there also your Lordship right to consider my documents.
That's what I'm saying.
Yes, sir.
I'm saying the same thing.
Document I'm कहूଛୁ
By the authority. I'm given one representation by Annexure 3, your Lordship, since 2017.
It is with us. We are also examining the same. We'll consider it in accordance with the law.
That is not in this case, your Lordship, in a similar case.
It's all right. But, the grievance of the petitioner is that he has given a representation dated 10/9/2020, 10/9/2017 to the Director General of Police, setting out of his defense. The investigation is still going on. He has filed a certain document along with the representation.
Under Annexure 2.
Mr. Mahapatra and Counsel for the petition submits that none of his documents submitted
Gotiye document
before the investigating agency has been considered. Controverting the aforementioned submission of Mr. Mahapatra, Mr. Maharana submits that the document which has been filed furnished by the petitioner to the investigating officer shall be considered in accordance with the law. In accordance with the
Subject to condition, petitioner will cooperate.
and subject to condition that petitioner should cooperate in the investigation. It is accordingly expected that the investigating officer shall consider all the documents to be submitted by the petitioner during the investigation, subject to the petition.
As per in accordance with the law.
Cooperate with the investigating agency and
In accordance
documents that we consider in accordance with the law. Yes. Of the disposal.
68.
May I please, Your Lordship? Here is a case, my lord, if the police officer was trying to recover money from one of my lord, may I say the background of the case, what has happened? My lord, I am a owner of a restaurant. I have taken some money from one person to invest in my restaurant, my lord. There are some dispute, my lord. For that, he wanted that I should return the money. I was going on paying, my lord. And
You had taken money from
Yes.
Opposite party number 2.
Yes.
Yes.
That is not dispute.
For business purpose.
For business purpose. Now he involved the police to recover the money from me. But the police officer again and again called me. He called my wife. He came to my residence.
If you don't give, then instead of I'll better that employ police.
My lord, my lord, gave through my associate gave a notice to the police, that is the Annexure 1. After getting
What
this,
was the amount, total amount?
total amount was 8 lakhs. 2 lakhs has already been paid. 6 lakhs will be paid. I am going on paying. That is a different issue, my lord.
There is a direction from the under 156
just-
to register an FIR
just a
and
minute.
investigate.
No, come to the main issue. Forget about 156(3) FIR and all. 8 lakhs.
Yes.
How much you have paid? How much?
I have 2 lakhs I have paid. Now that is now I am challenging this on the ground. He has filed the complaint case directly praying to send the complaint case under 156(3), which has been denied by this on Apex Court in Priyanka Srivastava case, that you cannot have a choice. You directly making a prayer that you send it under 156(3). It is the prerogative of the magistrate whether he can conduct the inquiry under 200 to 200 or he can send it to 156(3). Your Lordship may see what is the prayer in this complaint case I have annexed.
You forget about everything. Pay the money and finish it up.
Now I am going on paying. That is not a issue, my lord. Here, my lord, they are harassing me. Now they have taken me to the police station. They have forced me to write a undertaking that you pay, otherwise I'll arrest. That is why, my lord, I have come before your lordship, my lord. Your lordship may see the page 37. What is the prayer?
37.
Page 37. The prayer of the, my lord, in the 1cc case.
Yes.
In February, I have paid, my lord, 1 lakh rupees. Thereafter, I'm going on slowly. I'm going on paying. There is a dispute, no doubt. But police is not a, my lord, recovery agent.
37 years.
Page 37. The complaint therefore prays that your Lord honor would be graciously pleased
All
to.
this kind of rare, you know, what kind of draftings are being made by the court, by the law.
This has been my lord, deprecated by the Honorable Appeals Court in Priyanka Srivastava.
The affidavit is filed.
Yes.
The affidavit is there.
Affidavit is there, but you cannot make a prayer to, you cannot, the magistrate, you know, you don't do it. You send it to the police. You cannot say
have
that.
you have been sitting here in the court for quite some time now.
Mal-
You have seen what kind of parades are made in 482 petition.
that- But here
Come on, you tell me how will you pay and finish it up?
No, my lord, let them appear.
I'll issue notice, not that I'll not issue notice. I'll issue notice, I'll send you to mediation.
And
finish
my
up.
junior, my associate has also been made an accused in this case. Since he has given an, my lord, notice.
What is this? Lawyer, you don't leave lawyers alone. I'll issue notice,
Your
I'll
Lordship.
send it to mediation,
Your
don't
Lordship.
proceed.
Your Lordship. My,
Does the money matter? Why unnecessary?
Yes, yes,
Your
yes.
Lordship pleases.
I'll
Not
send it
only
to
one thing,
mediation.
Your Lordship, Annexure 3 is under challenge. How the court has passed the order 156.3 order, that order
That has
is,
not-
that complete
that-
order has not been annexed.
Better not to.
That is the only order. That is the order.
He is admitting the fact that there is a financial.
Yes.
Yes.
He has taken the money.
Yes.
And he started paying somehow 2 lakh rupees he has paid. Another.
Your
6
Lordship,
lakh.
place it
I'll
for
send it to
mediation.
mediation
Your
instead
Lordship,
of
please.
criminal case. It is better that it should
Yes, yes, yes.
settle here.
Yes,
Yes,
Your
yes,
Lordship.
my lord.
Right now. Right on. The petitioner is challenging the order dated 12/4/2024, whereby the court below, while exercising jurisdiction under 156(3) CrPC, directed the police to register a FIR in 1cc case number 57 of 2023. Mr. Paul, the counsel for the petition submits that the dispute is regarding payment of non-payment of rupees
6 lakhs.
8 lakhs. 8 lakhs in total, out of which
2 lakhs has already paid.
Out of which his client has already paid about 2 lakh rupees. He is ready and willing to make good the entire payment with comfortable installments. Taking into consideration the fact that the dispute is limited to the recovery of the amount due, I am of the considered view that the party should be relegated to the mediation cell of High Court, Orissa High Court, mediation court. The coordinator of the mediation cell is directed to fix a date for exploring the possibility of settlement and file a report before this court by next date of hearing. The parties are directed to appear before the mediation cell on the date fixed by the coordinator of the mediation cell. Issue notice to opposite party, written will open so. In the meantime, no course action. Yes.
Yes. At 138 of NI Act, my lord. Now the dispute has already been settled, my lord.
138
against conviction.
Conviction. After conviction.
30,000 of principal amount he has already received.
Where are the parties?
Parties are present.
Where are the parties? 108. You're talking about 108. Item 108. 144.
444.
Yes. 144.
Revision.
After conviction.
1 year conviction and double the amount 60,000.
Right. Who is Virabara Mulla?
Viravaram.
And Ashok Kumar Mohanty?
Both.
And they've settled their dispute and got the money. How much? What is the check amount?
Principal amount 30,000 has already received.
The petitioner. Petitioner? Petitioner was the accused in the 1cc case number so. What is the 1cc case number 1731 of 2004? And while the judgment dated 7/6/2008, the opposite party number 2. Opposite party number 2 was convicted, accused.
Yes, my lord.
The opposite party is convicted.
Opposite party, only opposite party.
The opposite party was convicted by the court of which court is this? SDGM Sadar Cuttack in ICC case number okay. At the petitioner was accused, convicted by the trial court, as confirmed by the
Confirmed by the
conviction and sentence passed by the court of SDGM Sadar Cuttack was essayed by the petitioner in the appellate court.
Additional session judge.
Additional session judge.
Fast track court.
Number.
Criminal appeal number 58 of 2008.
What kind of petition you people are filing, I don't know. Where is that order?
In the Lordship, in the first title I have mentioned the number.
What title? You show me the order judgment. Here. Additional session judge. Fast track court Cuttack in criminal appeal number 58 of 2008. Right, judgment dated 10/11/2010. The appellate court has upheld the conviction and sentenced the petitioner to what?
1 year.
1 year imprisonment
and double the amount 60,000.
Double the amount 60,000. When the matter stood thus, the petitioners and the opposite party have settled the issue. Both the petitioner and opposite party are present in the court, being represented by their respective counsel and identified by them. They filed the self-attested copies of their Aadhaar card to establish their identity. The opposite party number 2,
only opposite.
Petitioner and opposite party have filed the affidavit dated adjudication entering that they settled the dispute, and the opposite party, the petitioner has paid the disputed amount to the satisfaction of opposite party. Therefore, the intelligence service taking into consideration the information and the fact that this party is arising out of a complaint that is one that we did. I am inclined to allow distribution. Accordingly, the conviction and sentence order passed by the ad hoc additional justice fast track court by the order dated 2010 is what?
Yes, it has ready.
Next. No? Continue. Yes.
69.
May I please, Your Lordship?
69.
A conviction under 13(1)D and 13(2) of the PC Act, read with along with 468, 420, sentence is 3 years and fine of 25,000. I am on bail.
Are you in custody or out?
I am on bail, my lords. 3 years is the sentence.
Yes. The criminal appeals also is admitted. Mr. Sanjay Kumar Das, Sanjay Kumar Das, and Mr. Chadangi appeal for admitted. Sentence is 3 years. 3 years.
3 years.
Fine.
25,000.
On each count.
On each count.
Under 3 offenses on each count.
Each count. Right on. Admitted, sentence suspended, and have you have moved application for suspension of sentence?
Application for bail, my lords.
Application for bail and fine, state realization of fine.
Realization fine allowed? Application bail. Okay. Yes.
3 copy of the order may kindly be given.
Yes, yes. Next.
70.
maybe the appellant has been convicted under section 13(2), reduced 13(1)(d) of prevention of
I
corruption.
may be pardoned, my lord. I may be pardoned. This appeal may kindly be listed along with your lordship have already admitted co-appellants appeal number 365 of 24, 366 of 24.
364, 60. Okay. And the same order.
365 and 366. 24.
Sentence?
Same sentence. Your lordship have
What is
already
that?
admitted.
1 year
admitted
sentence under section 13(2), reduced with 13(1)(d) of PC Act.
Same
And
order. Same order. Yes. Next.
70.
77, 71.
71.
My lord, maybe the case may be urgent to some other day because
Sorry?
urgent to some other day.
Yes, urgent.
Lordship, after vacation.
Yes, yes, of
After
course. Yes.
73.
On behalf of Mr. S.K. Samantara, I may be allowed to place this matter.
Yes.
Well, the petitioner is challenging the order of NPW issued by the London JMFC Kodala.
When you were on the bail?
My lord, we are in bail
29/4/2008.
29/4/2008 and NPW
30/08/23.
30.
30. 30th August 23.
Okay. 500. Yes.
Well,
74.
Yes.
Bail on 21/5/2015. NBW issued on 23/4/2024.
500. Yes.
75.
Or 500.
75 minor NBW issued on 14/3/2023 minor. Released on bail on 27/9/2022 under Annex 2 minor BLFL number 4922 of 2022.
500. Yes.
76.
May I please, my lord? NBW 22/2024, my lord. And I'm on bail since 27/11/2018.
27/11.
11.
2018 is bail.
Pursuant to this honorable High Court.
28/2/2024. Okay. 500. Yes.
77.
My lordship. Petitioner bail on 1/10/2015 and NBW issued on 7/12/2016.
1000. Yes.
78.
My lord, order of cognizance is under challenge, my lord. Order of cognizance and non-bailable warrant of arrest dated 12/12/2008. In the meantime, my lord, the informant has expired and there are two accused persons in this case. Another one accused person has been released on bail, my lord.
You go and tell all these things. NBW issued on 12/12/2008. You are not on bail. You are
I was not on bail.
absconding. Absconding.
My lord.
Yes.
Absconding. Sorry, 1000. You go and appear. Yes. Next.
79.
With your permission, if I have played through Vishay Puri, my lord. My lord,
Yes.
the present petitioner has been on bail since 26/06/2020 and when NBW has been issued on dated 12/12/2022.
Okay. 500. Yes.
Obliged, my lord.
Yes.
Item 80.
Yes or no? Just see.
But 20th of September 2016 is bail. Well, item
80.
80 Belgium matter, my lord. Bail was granted on 28/7/2023 and NBW issued on 25/1/2024.
500. Yes.
Obliged.
81.
Please, NBW issued on 5/5/2023, man. Earlier bail on 22/8/17.
Why can't you speak little louder? What is the problem?
I am suffering from.
You cannot had lunch.
No, my lord. NBW issued on 5/5/2023, my lord.
Yes.
And earlier bail on 2022/8/17, my lord. 22/8/17.
500.
82.
Yes.
The petition was granted anticipatory bail, my lord, at page 35. Start from page 32. And in the meantime, warrant has been issued against him, my lord. I have passed similar order in this case, my lord, particular judgment of Supreme Court.
Maybe you are on anticipatory bail.
Yes, you can see the, my lord.
NDPS issued on which date?
You can see the last order that will continue with in judgment of Supreme Court, my lord. That is Siddharam Satyalingam, it will continue till in the end of trial, my lord. Same case, my lord, same affair.
307 is your date.
Yes.
Same order.
Only the BLP number has to change, my lord.
You change. Why don't you?
Yes,
change
yes,
it?
yes, yes. No, no.
Write down and give it.
Yes, yes, my lord.
Same order.
Yes,
Yes. Write down the over. Yes. 83.
83. Yeah, NBW issued on 9th February 2024.
Yes.
Released on bail of white BLFL number 12450/2023 on dated 14/11/2023.
500. Yes. 84.
May I please, Your Lordship?
Yes.
The petitioner was released on bail on 20th September 2016 and NBW was issued on 5/11/2022.
500. Yes. 85.
NBW order dated 24/12/14, my lord. He was bail on 6/8/2010.
14.
Yes,
14.
he was staying outside, totally unaware about the
1000. Yes. 86. Yes. 86.
86, my lord, Mr. Mishra is supposed to. Yes, he is there.
Lord, this is
Yes.
an application for restoration. The order dismissed. Yes, my lord.
Where is that order?
Page
6723?
6/7/2023. Yes, my lord.
Yes.
Page 9.
Page 9 years.
Annexure 2.
The application was filed on 4/8/2023 for restoration.
Non-prosecution.
Non-prosecution.
Restore to the file 1000.
the High Court.
Pay to Bar Association 1000. Restore.
No, the my lord, copy of the
Lord,
You give a copy of the CRLMC.
main custom.
My lord, may I just tell your lordships, is imposing cost, but I'll just tell your lordship, this matter was initially before with the advocate, was later elevated, and it came to me. And when it came to me, this matter got dismissed for non-prosecution because the Vakalnama was not there, and the name of the erstwhile advocate who was elevated was appearing on the cause list.
What, Mr. Mishra, do you want that I shouldn't allow it or what? I allow
Your lordship,
you.
I know, but your lordship is imposing cost. That's why I'm saying that this matter was initially before.
I'm sorry that you are hesitating to pay to the Bar Association. You have to pay it.
He is now
If you speak more, then I'll increase the cost.
Can I
also executive member of this bar association.
And your associate is a member of, he himself is a member. You pay 1000.
He is newly elected as the executive member.
Your associate is a direct beneficiary.
My associate will be too glad to pay that, but I'll pay that your lordship may restore. Your lordship may restore the interim order also. That's my prayer in the application.
Yes, interim order is restored. Interim order. Yes. 87.
My lord, I am in VC, my lord.
Interim order is restored subject to paying 1000 costs. Yes.
My lord, I am in VC.
Yes, yes.
The petitioner is the
Very
trust.
faithful, my lord.
Yes.
The petitioner is the trust who runs the college.
He has come against cancellation of bail.
Yes, let me submit, Mr. Saul, let me submit.
Yes,
Let me
you
submit.
submit. Yes.
My lord,
When was the
initially,
bail granted?
25/8/23.
my lord, there are certain facts which I should bring to your lordship's notice.
Yes, tell me.
My lord, initially FR was lodged under 417, 420, 506 and 34. My lord, the private opposite parties who are before your lordship 2, 3 and 4 are the terminated employees of the institution college. My lord, FR was lodged, FR no action was taken. I came up in CRLMP. This honorable court directed for early conclusion. In the conclusion, they gave a clean sheet. Then I filed a protest petition. In the protest petition, cognizance was taken. And your lordship will see annexure 7.
What is the offense? What is the offense here?
My lord, 420, they have embezzled more than around 2.5 crores of the institution money. And the bail has been granted, your lordship will see page 36, without imposing a single rupee money that they have to deposit. My lord, when there
now
is
you know, now you know if costs are imposed and the recoveries are made, then Supreme Court says that is onerous.
My lord, may kindly see page 36. Kindly see page 36. They did not appear in the court below. Then suddenly they appear and the SDGM on this JMFC grants bail immediately, in spite of the fact that I have produced document under annexure 7 that they have embezzled 2.75 crores.
1 minute. What is
Actually, there is no misappropriation. My lord, kind see the
No,
file.
I am not going to examine everything.
No. Why? What's
Bail granted by some court, I don't want to interfere.
yes, well, kindly see.
Mr. Bose.
My lord.
See, you come in a better case. Don't.
My lord, it is your lordship's decision. Your lordship may reject or allow my prayer. I have nothing to say. But your lordship may see the JMFC grants him bail without imposing any condition.
Let him file there, my lord. Let him file there, my lord. If I.
My lord, 2.75 crores of the institution money has been taken in private
Nobody, my
account.
lord, raising the real point, my lord.
Mistake of
1 minute.
My lord, 409 here, my lord. That is a circular of this honorable court when the offense 326 and so also 409 life imprisonment there, magistrate should not be granted bail.
409.
Yes,
No, 409.
my friend has
See, state is raising
409 cases, my lord, magistrate. Though the tribal magistrate, my lord, but the magistrate can't grant bail 409 life imprisonment there.
Yes.
For that.
Where is that? 103.
Charge sheet has been filed where the police has said
Where is the charge sheet?
No, he has not filed. I am supplying this.
Charge sheet. Cognizance is taken.
No, my lord. Cognizance taken, my lord.
Protest petition.
On protest petition, my lord.
Protest.
But 409 is there.
409 is there,
Yes.
my lord.
In protest
Your
petition.
lordship may see page 33.
470. He said
417,
420, 506,
409,
I no
34.
file. Final form.
That is not the
Yes.
cognizance.
Final form has been.
Cognizance. Come to cognizance. Page 33.
Page 33.
Cognizance is page 33.
Let him.
That is what he says.
Let him file and let him.
My lord, how can the
Let him-
magistrate
let him-
grant bail in
let him move.
409?
Let
What do you
him.
say?
My lord, even if my lord, you are up to your lordship, my lord, as because my lord, there is a circular, my lord. They can't grant bail to 26 and so far the 409, my
Where
lord.
is that circular?
But that is my lord, my
Where is that circular, Mr. Bose?
earlier, my lord, issued by this honorable court, my lord. Okay. And 409.
There is a circular, my lord.
Where is that circular? You give me that circular so that I can think over what to do.
Both the
Your
cases.
lordship
309.
Your lordship may post it on Monday. I'll produce that circular.
Mr. Bose and counsel for the.
May prevail after vacation.
No, my lord, I have objection.
हाँ ठीक है
1 minute.
देह खराब हो कमर को थकवा देह खराब
Then counsel for the state submits that. What about that circular? What are you seeing?
My lord, the
There is a High Court.
my lord, that might call for from the registry, my lord. If there is a circular, my lord. So far, I know, my lord, when I am
Problem
doing
is if the court will do everything.
Starting
from pleading to research.
earlier, my lord, year back, my lord, I had gone through once, my lord, while I am moving my application before the trial court, 14 and officer that has rejected. My lord.
21st.
My lord.
21st. Yes. Next. Get the circular, Mr. Bose.
Yes,
And
my lord.
speak-
Yes, my lord.
and Be in touch with Mr. Ragada. He will tell
Yes.
you.
Yes, my lord.
You try to get over that circular. If that circular is there, I may do one thing. I will set aside and allow you to move.
My lord.
Fresh application in accordance with the law. Wherever it.
I'll get
Yes. Just check it up.
My lord. I will.
Next. 88. Yes.
88 and 90. Here the state has filed this application challenging the grant of bail by the lower court. But what has happened is an elephant was electrocuted and the tusks were cut off. The accused is a supervisor with TPCODL and he is the person who has laid the wires. The lower court has granted bail on the ground that since the offense, the punishment carried is only 3 years, section 4141A of CrPC should have been followed. My only submission is that in a case under section 50 and 51 of Wildlife Protection Act 1972, CrPC section 41-41A is excluded because the arrest provision is under section 50 of the Wildlife Protection Act, which starts with a non-obstante clause.
Oh.
Your Lordship will only see the Wildlife Protection Act section 50.
Read it. There is non-obstante clause.
There is a non-obstante clause.
Yes. For example. In any case, I'll have to issue notice.
Yes, Your Lordship.
Let us, we'll examine that. Let us see.
The question of law is whether section 41 and 41A of the CrPC will be
In view of the
applicable
non-obstante clause.
in view of the non-obstante clause under section 50.
We will just issue notice to in both the matter.
88 and 90.
Issue notice. Yes. There can't be any interim order. He has already been released on. Yes. Next.
91.
91. No.
89.
89, 90.
89.
Or no bearer.
89 is there, madam.
89.
89 touch not.
No, no.
89 more.
88 and 90. 88 and 90.
90.
89. Right. Yes. 89.
My lord, may I please your lordship? The petitioner challenging the order dated 20th November 2023 passed by the learned senior civil judge Women's Court, imposing condition that he shall appear before the court on
Where is
each
the condition?
on
Where
each
is-
date of
Where is
posting.
the condition? Show me the condition.
My lord,
Condition. Which page?
Page 10, my lord. Page 10. Page 10.
Ah.
Letter, my lord. 2011-23.
Really about
Consent 2.
Custody.
He shall
And he shall
appear
cooperate with the investigation.
and he shall appear.
before the court each date of posting. Yes.
my humble prayer before lordship with great respect is that the petitioner is a government servant and working as an accountant at
Agenda would require 370.
HRMS.
So, right, petitioner is agreed by the condition imposed by the court below while enlarging him on bail. The condition that he shall appear before the court on each date of posting till the disposal of the case. Of course, the petitioner is agreed by the same, and has filed the petition under section 439 clause 2 of CrPC. Let me consider the petitioner submits that the petitioner is a government servant.
Government servant.
Government servant. So therefore, by the condition, his right to move application under 203 and 205 CrPC is precluded. That should be your argument. I'm right.
He is doing all these things for the benefits of the public servant. My lord.
Taking into consideration the Mr. Bragada IPS for the state and oppose the bread. Taking into fact the facts of the present case, I'm inclined to allow the petition, and the condition as aforementioned is modified, and it is directed that the petitioner shall appear before the court as and when the court directs to appear before it during the trial. Such modification.
May I pray one thing, my lord? My name may be reflected because I have no power in this case. Therefore, I am praying, my lord.
Write down his name. Give your
Jagannath Gochayat.
Jagannath Gochayat.
Jagannath Gochayat.
Gochayat. Yes. Next.
91.
Bless my lord.
91 is also modification of the condition number 3, 4 and 5, page 11.
Page 11.
Yes.
Mr. Bragada, just see. What are the conditions? Condition number?
Dispute. Condition number 4 and 5.
He shall appear with the IO in week, preferably.
Appear before IO. Preferably on Monday, and
This is the
as and
dispute.
when the IO calls you.
This is a dispute between daughter
Whatever I am not in. You as and when the IO calls you, you go in.
And also, my lord, the trial same thing. My lord,
each date posting of the trial is instead of that.
Petitioner is agreed by the condition number 3 and 4.
4 and 5.
Sorry, 4 and 5 imposed by the additional sessions judge Asla while enlarging him on bail Why is it's order dated 5/4.
Your lordship may say her because the petition.
2024. The conditions are, the condition reads as under. The condition like it. 4 and 5. Page number 11. Mr. Ragada appears for the state and submits that since the investigation is still going on, the petitioner is required to appear before IO as and when he is called. And he is the petitioner.
See, madam. Ready.
As and when he is called. The petitioner is also required to participate in the trial. Accordingly, the conditions has to be modulated. Okay? Taking into consideration the submission made at the bar, condition, the aforementioned two conditions are modified by the following two conditions. First of all, she shall appear before the IO of the case as and when the IO calls him for the purpose of investigation. Second, the petitioner shall also appear before the court as and when his presence is sought for during the trial. Yes. 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 Some special notice matter. What?
Item number 92.
92. I'll take it serious matter.
Yes.
92.
But here the same point that after the closure of the departmental proceeding, whether a criminal proceeding can be initiated against.
Can be initiated.
My lord. That the my lord has been fixed to 26.
26. Yes. See, Radhesham, you are relying upon Radhesham. Radhesham is a case where
Adjudication proceeding.
adjudication.
Well, I am not relying. I have drawn the attention of this honorable court, and this honorable court has taken note of Radhesham, Kejriwal, and others. And the decision is Minaketan Pani.
And the
My lord, that has been construed. 3 Supreme Court judgments have been construed by this honorable court, and they have taken note of everything and passed the order.
What is the fate of Minaketan? Was it challenged in Supreme Court?
I don't know. I don't know. Crime
Whether
branch.
Minaketan was challenged.
No, I don't have that. State was there. So was Minaketan.
It was a case investigated by the crime branch, and one of the most.
Minaketan is in its favor. That the first court has passed that order, taking into consideration many aspects of it, including Radhesham. Radhesham is relied upon, but it is the case of departmental proceeding. Now the issue is if a departmental proceeding somebody is exonerated, whether on the same facts, same basis, whether a criminal case can go on or not.
I think the one
my
lordship
I passed the order. I didn't agree with it. I said that see the law laid down of the Supreme Court is adjudicating process because the standard
My
of
Lord
proof
Pen
are
can
different.
also my Lord Pen can also remain present on that day to assist because this is a case which has got a very far reaching.
Right.
So
I would like to get appropriate assistance.
My
so
lord,
that,
my lord, my lord.
we can enhance Minaketan theory.
Or it can be deprecated. My lord, it can be referred to a division bench because this point is the point of law, and that too because I have relied upon 2-3 full bench judgments of our High Court and other High Courts, which will be considered out of 3 judgments of the apex court.
If there is a conflict, we will refer it to larger bench. Otherwise, we happen.
The thing is that so far as the Minaketan Pani is concerned, the issue, so far as our case is concerned, issue is whether the public servant facing criminal trial under PC Act, in respect of which sanction has been accorded by the competent authority in consideration of the materials and due application of mine, be quashed in view of the department exoneration in departmental proceeding. That is the cross of the case. Not in the so far as the other cases and the cases relied on the Minaketan Pani.
Minaketan,
that was not the issue.
Sanction was not
there, and it was not the issue.
Yes, Minaketan Pani. My learned friend must not be knowing because I know the facts of that case. That was most sensational case of that.
I think Minaketan Pani you appeared.
Yes, Minaketan Pani, my lord, that was the most sensational case of that period, my lord. Because son of the education minister, this and education minister, his mark was enhanced by the board.
Oh, that case.
That case. That was one of the most sensational case, and accused
Their
was.
sanction was there.
No.
How can you say no? The state can say better. You are appearing for the vigilance.
No, no, petition.
His crime branch was the investigating officer. They had it was argued at length before the Honorable Chief Justice, my lord. And court has also applied. That was all everything has been submitted. Again, I want that it should be set at rest, because time and again my lord is opposing.
And another aspect is it's my duty to bring it to Lord's knowledge. Thing is, the similar issue, so far as PC Act is concerned, this is pending before the Honorable Apex Court. There are 2 to 3 cases. It has been referred
on that day we will argue everything.
No, Supreme Court pending.
Kill court's time.
So far as the PC Act is concerned,
We'll
their
see
division measure.
That they will see. And I must suggest you one thing. You assist the court, don't in these kind of cases, don't follow the process of adversary litigation. Try to assist so that law can be laid.
Law can be this.
The thing is that I have given so many judgments. I prepare a note.
So prepare that note so that law can be what he
Madam.
says. What he says.
I want that
good law. Then it's good law. What to do?
I want it should be retested.
Right. Then we will refer it to larger bench.
That's
somehow we will not agree. Then well, situation. Yes. Next. Yes,
on 46th balance.
Yes.
Balance, if any adjournment application will be filed, that will.
Yes. Mr. CBA Council, appearing for the petition submit that he will be moving appropriate application for the court below for seeking adjournment, going to the fact that the matter is sub judice before the court. Yes. Yes, Mr. Koda, what is this?
On this case, what happened, my lord? I have though not received the instruction, my lord. So far, their petition, my lord, shows that so cause notice issued on 6/4/2024, my lord. Then, my lord, 24/4/2024, my lord, the IO directed to serve notice to appear before the court below, my lord. He appeared before, did not appear before the court, my lord. And then I have taken him to the court and produced him before the court, my lord.
No, everything is all right, but what is this government surety?
But that has already gone, my lord. The moment they have not, my lord, admitted that fact, my lord, and taken to custody, my lord, he has to file fresh, my lord, the application there before the court below, my lord. This order has gone, my lord. He has not any force, my lord. The moment he has not honored that order, my lord, that order has gone, my lord. Already goes. That order not in existence, my lord.
He is not in a position to honor the condition.
That person not in existing, my lord. The moment he has not honored the order, and that order, my lord, he has taken to custody, my lord.
He is there in custody.
In the custody, my lord. He has to fresh apply before the court below for execution of bond or the bail, my lord.
Well,
that order not in the existence, my lord.
Well, just I'm clarifying.
It was a case of 108, 110.
110, my lord. Admitted 110, my lord. That order, my lord, he has not complied with that order, my lord. For that, he taken to custody. That order not in my lord in force, my lord. Since he has been taken to custody, he has not obeyed the order of the court below, my lord. And he has to approach afresh before that concert court, my lord.
Yes, Mr.
Just I'm clarifying. Well, it is a case of 110. What you have said, we came to know from notice. The law provides 100. What is the 110? If anybody has a case or antecedent or he is involved with any sort of crime, the person can take 110. Number one. If presume that he is accused of under 110, you have to provide the documents, you have to supply the documents, you have to go to what charge has been made. You have given notice on 30th. He is present before the court on 30th. He didn't have a right to ask the court what to the charge for whom I will be giving furnish 1 lakh rupees and 2 government securities. This court has never allowed him anything.
What is your antecedents?
Nothing. Only he has what I've heard from his parents. He was given a speech on behalf of Vishwan Parishad. This police station has cautioned him not to do. Then they stopped the meeting, they came away. Thereafter, notice has been gone and they have arrested.
No matter.
So till now he is arrested on the ground that 110 is there. and they are not providing any documents.
No,
They are not accepting the applications.
That is not correct, my lord. And see, man, their petition, my lord. I have not got instruction till yet, my lord.
Yes.
Their petition, my lord, page 20. My lord, notice first issued to on 6/4/2024. Keep so cause, my lord.
My lord, perhaps these officials are not properly enlightened to government council. Lordship may see the page 37. Page 37, annexure 5. Lordship may see.
My lord, soft copy, how can I got?
No,
I have to take instruction.
Read it. Padmini Das, 48
Yes,
years.
his mother has written a letter on 11/5. Prior to that, we have written to the collector. Nobody is listening. They are not accepting the application.
I am not on that, but I am
saying,
only on this issue. Come to page 21.
My lord.
In a 110 CrPC proceeding.
That is not any force, my lord. The moment he has taken to custody, my lord.
Because of this only he has taken into custody.
My lord, he has to apply, my lord. He has
How can this kind of condition?
He has to give so cause, my lord. I am not, my lord. This notice is not, my lord.
No. He says that you come and give so cause. But this condition. Yes. What are the condition? 1 lakh rupees,
my lord,
with 2 government surety,
my lord,
for a student.
Government officer, class student.
Not, my lord. What is my lord allegation so far? Their petition, my lord, page 20.
It appears to be political.
Page 20, my lord. Allegation that you are one noted antisocial criminal having badly reputation in the locality. The delinquent have charged with different criminal cases and he is a die-hard habitual offender. He was always creating panic in the different cases.
How many antecedents?
Who don't have? That's why I have given affidavit. By we have affidavit mentioned.
The precondition of 110 is
habitual offender.
Yes.
Habitual
Yes,
offender.
yes.
That's
We don't have a single case.
And using the word like love jihadi and instigating teenagers to take revenge and save out the sisters, giving rise to every strong communal feelings. There are their allegations, my lord. I have to take instruction
on Friday.
Friday.
My lord, Lordship may issue notice. Only my limited PR will be. Lordship may release the petitioner bail. Nothing is last 13 days. 1/5/2015 he has taken to custody. That boy don't know why he is arrested. Till date, they are not providing any copy. Now, council, this council is there is a morning court now. They are morning court. They have.
He has to appear there.
Issue notice returnable Friday. The petitioner is directed to move application for grant of bail before court below. If such application is moved, the same shall be considered in the same way. But tomorrow, move the application.
My lord, we will move the application. I am abiding the court's order. My lord, tomorrow will, because court direct, they will consider my application.
I'll direct the.
My lord, what I am praying, my lord.
Yes.
My lord may fix any condition. Because 1 lakh, 2 government surety.
I could have done it if you would have answered my questions. You tell me you are antecedent.
We don't have any antecedents. But if lordship required, we will file affidavit.
See,
we already mentioned our petition.
See, that's what I'm saying. If you by the time you will file affidavit, it's better that you file an application tomorrow.
My lord, already I mentioned our petition. Lordship may see.
See, precondition is you must be an habitual.
That's what.
Page 20 says that.
And Soko's notice
you are antisocial and all. I don't know how many cases are there.
Soko's
How can I release you on bail?
What I'm saying, my lord. What I'm saying, my lord. Here, Lordship may otherwise Lordship may keep it tomorrow.
Tomorrow I am giving an option for you to move an application and the trial court will consider for grant for bail. And insofar as the larger question is there, and Friday I am keeping it. That's the best thing I can do for you. Tomorrow, Friday the matter will come up. Tomorrow he will move application before court below, and if such application is moved, the same shall be considered and give the copy of order today itself.
Yes.
Take the copy of order.
Oblige.
Move the application. Somebody's liberty is concerned. You can't. Free copy. Free copy. Yes.
93.
Yes. 93.
93.
Yes.
There matters the present petitioner is filing this application to passing the proceeding against him. Had PS case number.
You forget about PS case number. What do you want?
Malasip.
Entire proceeding to be quashed.
Yes, Malas.
What is the proceeding you are drawn against you? Complaint case.
No, Malasip, it is a simple affair. Malasip lodged by one Chinmoy Sahu
In
who
which
is
case
the
it is
one of
still on?
one of my cousin brother, and
That
he
is fine.
that he stated that I instigated him to pay rupees 1 lakh in a consultancy. That's why he cheated by one Prabhat Das. That is the allegation. In regards of that, I am released on bail and deposit rupees of 99,000 as surety. My lord, that as per the allegation, page 90 is the malus, the fact malus complaint. The page 90 is the fact malus.
You forget about fact. Why have you invoked? Why
Malus.
jurisdiction of this court? You have came to the court earlier also.
Yes, malus. In CLMP, malus.
What is that?
That to file an secret direction from this honorable court.
For charge sheet.
For charge sheet.
Charge sheet is now filed.
Yes, malus.
Now you are asking for question.
Malus. Because no case is final against me, malus.
You don't leave a single opportunity to stop. Every time you come to the court.
No, malus. I mean, as per the procedure, malus, that allegation is I am instigated him to pay the rupees 1 lakh.
Yes.
To the consultancy. And the informant is pay the rupees 1 lakh without my consent. And now he cheated by the consultancy. But how I connected in this case?
You instigated.
That is the question. That is the fact.
That fact has to be taken in the trial.
That fact stated by the informant. That my brother instructed me.
In the trial.
So far as one of the person is
another opportunity should be given, my lord. Notice return, my lord. With endorsement, 7 days absent, hence return to sender.
Okay.
Press notice.
Press notice be issued to opposite party number 2. Return.
As per the section 64, because he intentionally not received the notice.
Next time you point out to yes.
If my kindly order the as per section 64 of the CrPC, then if he may be not received the notice, then elder male member of the family
don't take preemptive order.
Sometimes
Do it next time when if will not receive, then we'll see. Yes.
94 to come after vacation, the mediation has not been completed.
Awaiting mediation report. Adjourned. Yes.
95.
95.
Extension of time, my lord.
What extension of time?
So, petitioner directed to appear before 20th April.
How much time is it?
Just 15 days.
25th June. By order dated 18/3/2023, petitioner was directed to appear before the court below on or before 20th of April 2022. He takes extension of time for the reasons stated in the application. The time is extended until 25th June 2024. The petitioner is directed to appear on or before such a yes.
96.
May I please your lordship, my lord?
Yes.
This is being the father, my lord, who takes shelter before lordship for questioning the FIR by annexure 4 lodged by the son, my lord.
Yes.
In the last occasion, your lordship was pleased to issue notice, and accordingly, the humble petitioner served notice on 1st May to the
JC service.
The postal tracking report is that notice returned not served.
Press steps maybe. Petition is directed to take first step to serve opposite party number 2.
Opinion number 4.
Interim order to continue.
Okay.
Yes, next.
97.
May Prejudice.
Yes.
Here, my lord, petitioner is challenging the order of cognizance, my lord. Here, my lord, I have annexed the FIR and charge sheet and medical everything, my lord. The case is that
informant is the victim, who is a major girl, lodged an affair with an allegation that the marriage of the my lord, ring ceremony of the petitioner has done with the my lord, the petitioner, my lord. And thereafter, my lord,
Question of
few, few days after, my lord.
But charge sheet has been filed, my lord, so as the petitioner as the absconder, my lord.
Stating my place in the case. Your petitioner is army personnel, man. And thereafter, my lord, she has stated that while she was talking with her my lord, boyfriend, my lord, that has been written that came to know to the petition came to know she has some relationship, estimated relationship with another boy. That fact remains. Then thereafter, she alleged that the petitioner brought on my lord 19 to 2023 to the college, my lord. That is a holiday, that is Sunday, my lord. And thereafter, allegation that she committed my lord, sexual assault against the petitioner. My lord, I have annexed all the documents. So far as my duty chart is concerned, I was on that day duty. When that fact was known, the marriage proposal was cancelled. And I have annexed all the detailed documents. No, but cognizance has been taken.
Go and your plea of alibi has to be tested.
No,
Earlier, APLPL was filed and which has been dismissed as the withdrawn.
That's why I have challenged.
And basically, you have come because you have not got the bail.
Yes, ma'am.
And my lord, a particular day, my lord, that is also some that investigation.
All these things, can I test it?
And another thing, my lord, the medical.
Let it be. How many things you will tell? You are the entire case is you set up a plea of alibi.
Another plea can be taken. Another thing, not alibi, my lord, and medical document also, there is no sign and symptom. Another thing, my lord, that day which has stated that is a holiday, my lord. In the holiday house, you go to the college. She has stated. She has stated that investigation has not been taken in that effect, man. And to that effect, settlement is also going on. I have also made informant as also party, man. And because of this, marriage proposal was cancelled. That's FIR has been registered. I am all these things are there. Why is not appearing? Why is it? I have appealed to council, man. You will also kindly see the order. I have already appealed to the council 25/7/2023, page 38. I have already appealed. Actually, Dilip Kumar Patnaik, we filed Vinava in favor of accused. Same is accepted. You also filed petition for time on the ground stated there. Time petition is allowed. But through the advocate, he has applied. And what that record has not been regulated, the time petition was. And argue, sir. You want the entire trial has to take place at the cognizance stage. How can it be possible? But my lord, I have made a informant also party. Then if that is the case, then I will simply issue notice. You'll not civil so simply issue notice. Yes. And we have one thing, no, that only for that one thing only I am not issuing. Yes. Call her, let us see if you can check. And also I miscase my lord. And then miscase notice. Issue notice on miscase. Next. 98.
Item 98, your lordship, there is a noting that defect number 6 and 19 is there. I may be permitted 2 days to remove the defects, your lordship.
Sorry, I didn't follow you.
Item 98, your lordship. Yes, lordship. Defect number 6 and 19.
99.
This is a case to cause the charge being framed under section SC ST in part. So for the FIR, my lord. So for my lord, to peruse the FIR by annexure 1 page 12. It goes to say that on my lord on 6/9/22, when the informant along the other person taking away the house from the.
What are you asking?
To cause the charge being framed under section SCSA.
Where is the charge?
But that was missing, my lord. I could not file it. But subsequent I filed it on next day.
Sir, you are seeking passing of the charge sheet. Where is the charge sheet?
Charge sheet of them, my lord.
Yeah, prayer is to pass the charge sheet. You
Charge
have
sheet
not
in
filed the
part, my
charge
lord.
sheet.
In part, my lord, the order is there.
Adjournment to file the medical document and remove it. Yes, next 100. Item 100.
Charge sheet has been filed. I may be publicly filing the charge sheet. I have already cleared the difference to the morning. Much obliged.
101. Yes. Who is there?
There was one I have got the instruction matter from the concerned Higher Matter Superintendent of the Police is saying Bhubaneswar regarding a urgent because the concerned officer has reported to the election duty. So he's playing for a urgent for the election. State mechanism.
May I please, my lord? I'm appearing to VC, my lord. But here, I've seek this honorable court intervention for modification. Probably I am under wrong nomenclature. my lord.
Modification of what?
Modification of bail order at page 23. Modification of condition of bail order. At page,
Condition of bail.
yes,
Where is the condition?
page 23. Page 23.
Condition.
Page 23.
Condition number?
3 and 4.
Page 23, beat number what?
3.
Which condition?
3,
Not
3,
modification.
3 and 4. 3 and 4. 3 and 4.
What is this kind of condition? You are fixing time for appearing to arrive.
My lord, no, this is a matter. May I submit, my lord? This is a matter of year 20.
I understand. Investigation, he has to cooperate in the investigation. Whenever the IO calls, na?
Yeah.
If you fix the time, IO is also stuck.
My lord, the date and time.
He
That,
came to follow. He must be there somewhere in election duty. Then what will he do? This man will go and see.
that effect, my lord.
That effect. He again well. 3 and 4. 3 and 4.
Probably same as item number 91. Probably. DPO place.
Page number
23. Probably same as item number 91.
Yes, next.
DPO place.
Okay, sir. 105. Okay. 106. Order of comprehension under challenge. Expenses under section 447 and 506. Expenses under 447 and 506. Yes. Well, our case is that, my lord, when an allegation is made against a company, when allegation is made against a company without including the company as an actor, cannot proceed individually against the allegation. But here, my lord, as for the FIR allegation, we have installed a petrol pump, and inadvertently, as per the complaint of the informant, was trespassed into the land. Was 447 and 507. The second ground is over in. I am the one of the managing directors of the company. Which company? Tractor India Private Limited. What is this suit is about? Suit is about the prayer that the demarcation report given by the executing magistrate. We will issue notice. Notice. Yes. Next.
107. Just stay, my lord.
I'll stay home.
Your lordship, kindly taken up day after tomorrow, your lordship, the wife is going to appeal. Is that possible? Husband wife dispute.
Huh?
Husband wife dispute. The wife will appear.
Are they appearing?
They are staying together, your lordship. Kindly taken up day after tomorrow. And sort of. Yes, your lordship. Day after tomorrow.
Where is the charge sheet?
Charge sheet computer.
363.
FIR. FIR का तो charge sheet में file इसलिए FIR को पसंद करो. So I don't have a copy of charge sheet. Kindly take it up 20. So that is
Thank you that you have given me date.
So I am saying that you didn't have that time. I will get the charge sheet copy, certified.
I thought that you are calling me to your house.
No.
Keep it. This trend I don't understand. When you ask a court for an adjournment, you simply ask for adjournment. Thereafter, you say that he possibly give a date. You don't fix a date and come. You see the calendar and say that fix this date.
Three defects are there.
There are many other issues we have to see. Okay. Anyway, yes.
109.
Come with the charge sheet.
Yes.
My lord, the matter is going to be settled between the parties. And the informant is an outside of the state. Therefore, I pray for after vacation.
109.
My lord. Oblige, my lord.
110.
Notice is issued, I think.
Write down. Which of shall I record that you are settling?
My lord.
On that ground only notice of this.
Acha.
Yes, on that ground only notice.
Sure.
Oblige, my lord.
Yes.
On that time I have taken the notice, but nothing, sir. I will take first.
Press notice.
Insufficient address असतं तर उडा face notice नाही.
Press notice.
Address tag correct address आहे.
Correct notice. Opposite party.
As per the FR notice. Dita address ଅଛି ତ ସେ dita address ରୁ ଗୋଟେ address ଯାଇଛି out address. Foreign address ନେଇଯିବ.
Alternative. If notice to opposite party, number 2 in alternate.
Opposite party note 2.
2 in the alternative.
Yes.
111.
111 noting is the requisite has not been given. In the meantime, I have filed the requisite, my lord, to issue notice to opposite party note 2, my lord. It is my fault.
For your fault, you have
Yes, sir.
Huh?
Because my fault, I have given a
You have taken entry model.
entry model is there since long, and I have given a copy to the council who is
How much you will pay to the bar? I will not. It is volunteer. It is no compulsion. Nothing compulsion. You.
Whatever.
No, I will not say. You tell. If he will say less, then it is insult to him.
Yes, that is why.
If I will say more, then it is a burden to him. He is stuck now.
Yes.
You decide and tell. Don't tell anyone in the court. 1,000. Pay 1,000 to bar. Subject to 1,000. The requisites to be filed within 1 week.
Already filed is MB accepted.
Requisites filed belatedly may be accepted by the registry and issue notice to the party.
Opposite note 2.
And number 2, subject to petitioner voluntarily depositing 1,000 rupees.
To the High Court
bar. Voluntarily. It's not imposition. Yes.
Entry model
will continue. Entry order to continue.
112.
Notice by steps nahi na. They have not taken steps for issuance of notice.
Stay nahi to?
Stay.
No, my lord. On behalf of dear Mahapatra.
Rupees 50,000, your lordship directly, lordship kindly see the order dated 20 March 2024.
Simply adjourn, or there is no stay. If there is a stay, then one can understand.
My lord, on behalf of dear Mahapatra, kindly adjourn the matter.
Notice. You take steps to issue notice.
Or entry model to be continued.
If there is no entry model, where is the entry model?
20th March 2024 is there an entry model? ଅଛି ନା କଣ କାହିଁକି ମୋର ଲାଗୁଛି 50,000 deposit କରିବା ପାଇଁ direction ହେଇଛି?
No, we can 50, we can one, subject to petitioner continuing paying regular maintenance to petitioner, execution proceeding. No, execution proceeding I have said you don't serve. What is this? Is a DV case. It is a DV case, maintenance case, and you don't pay 50,000 rupees. You don't pay this thing. This is very bad. Entry motor bracket code. Bracket deal.
Sorry, my lord, please.
See, it's a,
One chance.
what one chance? Somebody's maintenance is the question. The lady is in the problem. And you obtain a stay and you don't file process fee.
One chance, my lord.
Then you deposit instead of 50,000 deposit 1 lakh. Arrears are huge. What is this? This is unfortunate. You 50,000 rupees you are supposed to deposit. You have not deposited.
No, the amount deposited before
Where is that? Show me. You have deposited 50,000 rupees.
You will also keep it the two days.
No, keeping. You tell me.
Because he after pursuant to lordship's order he was released, and after his release he was.
Petitioner undertakes to deposit further amount of 50,000 within 1 month.
Yes.
From the date of the release.
Yes.
You said that you are in custody. I released you with that condition.
No. After your lordship's order, he was released, and thereafter he has deposited. I will produce the. But
And
only thing.
are you paying the regular maintenance?
Regular, that part, since I don't have any instruction, I will have to take it. But
How will that lady survive if you don't pay?
well, in fact, that lady, she is not. That is a disputed question where that will be decided in the appeal. I am not going to into that because.
Mr. Mahapatra, led counsel for the petitioner seeks an adjournment on the ground that requisites could not be filed within time. On 20 Commission, entry order was granted, subject to petitioner paying regular maintenance to opposite party. The execution proceeding was state. The petitioner was also directed to pay 50,000 rupees immediately after his release. Mr. Mahapatra for the petitioner submits that after his release, he had already made good the payment. However, he doesn't have instruction regarding the payment of regular maintenance to the opposite party. Subject to petitioner strictly complying the order detailed by way of last and final opportunity, 1 week time is granted to serve the opposite party number 2. It made clear that no further adjournment can be given, and the interim order granted to the petitioner can be automatically vacated in case steps are not taken to serve the opposite party number 2 within 1 week. Yes. Yes.
113.
Right, please, your lords.
Yes, sir.
Your lordship granted the relief, but I seek modification to make it functional.
Modification of what?
Make it functional. Your lordship may say that on the same day he shall appear before the lower court and the higher court, and it shall be decided on the same day. Parity, your lordship has already.
I have said everything.
No, both the courts.
Both the courts.
Because
have you tried?
No.
First court will give you bail.
Why are you if it doesn't give, then he shall have to go to a higher court.
Modification, I don't know.
Your lordship may say that one day disposal by both the courts below.
You are supposed to appear on 30th April.
My lord, that extension, my lord.
That is gone.
That is
there.
My lord.
Led counsel for the petitioner seek modification of the order. Order dated 1/5/2024 or 24.
Extension of time.
With the effect that appear before the court on or before 15th of June 2024, and move appropriate application under law. If such application is moved, the same shall be considered on the same day by both the court.
My lord.
Both the court.
My lord. And priority shall be maintained.
That is there under. The rest part of the order will remain unaltered. Yes.
114.
Yes.
The order passed by your lordship in my absence, there is such that this matter is not a Belgium matter, your lordship.
Absconder NBW.
Absconder NBW. I am challenging the order issuance of NBW as well as the cognizance.
NBW order, you tell me.
NBW data.
Yes, lordship. In 1912-2023.
19/4/2023.
19/12/2023.
19/4. 12. Only the bar. Absconder. 500. Yes. Next.
116.
Again. He जो order टा अच्छी the petitioner was on bail. Seita modification was not on bail. Paragraph 2.
14. 114 na?
Yes. Paragraph 2. The petitioner was on bail, but petitioner was not on bail.
Oh, modification.
Yes, Lord.
Right down. The modification order. Petitioner was on bail, na?
Yes.
Petitioner was on bail. That part you remove. Charge sheet was filed against the petitioner, so he given absconder.
Yes, sir.
Absconder. And thereafter, for non-appearance, NBW was issued on 19/12/2020. Para 2 days. Para 2 days.
116.
Maybe pardon to mention item 115, but I was just informed that the judgment has been reserved in this matter. My lord, in the first item, my lord, I am appearing. My lord, I may be given an opportunity to argue.
Which one?
115.
Huh? You are appearing for whom?
For the first appellant, my lord.
File written submission.
My lord,
File written submission. Where are you?
my lord, I do not know.
Okay, anyway.
My lord,
file
the
written
in list, my lord, it has come now.
Written submission is more effective than oral hearing.
My lord, just one opportunity for lordship grants. My
That's
lord.
right. You file written.
I'll file it, my lord. My lord, may kindly also grant me one opportunity of hearing.
16th to be mentioned first sorry first
to mention possible. Yes.
I'm grateful.
to be mentioned.
I'm extremely grateful, Lord.
At this stage, Mr. also mentioned who appearing for
The first appellant, in the first case, Your Lordship, Sushma Singh.
Sushma Singh. Your Sushma Singh is for which respondent?
116.
I'm so sorry, Your Lordship. I'm so sorry, Your Lordship.
Second, 115.
Sorry, so
16 I'm calling you.
I'm so sorry, Your Lordship.
Yes, 16, you tell me.
I may be pardoned, my lord. This item are listed earlier on 2 occasions, my lord. Already paper 4 sets of your lordship may kindly have a glance to the cause list. Paper books office may be directed to accept the paper book and be supplied to all the councils and let it be listed in the usual course for hearing chronologically. I pray before your lordship.
There is an order. Yes.
Office may be directed to accept the paper book.
Already there is a direction.
Yes, my lord. Why it is indicated in the cause list?
Okay.
Cause list, it has been again indicated the same thing, my lord. What was indicated in the earlier?
116.
In usual course, it will be listed. It may be listed in hearing.
My lord, there is an IA in 116. I mean, my first case, there is an application for stay of the order of conviction because, my lord, my service tenures have been cancelled. Your lordship, may kindly.
Convictions are never stayed.
My lord, may be permitted to satisfy.
Okay, then after vacation.
As your lordship pleases.
I will file an objection, my lord. Let it come after vacation. I will file my objection. If so wants. When the matter is ready for hearing.
I'm grateful, Your Lordship.
You are
And
relying upon Navjot Singh Sidhu.
my Lord.
As
And two
though
more
he-
judgments, my Lord.
Judgment.
My Lord, and two more judgments, my Lord. But Your Lordship knows, my Lord, there's a very small gap, but may I try to convince, my Lord?
Navjot Singh Sidhu will not help you.
My Lord,
Anyway.
I'm grateful, Your Lordship.
Satisfy me.
Your Lordship.
Your Lordship is aware about K.C. Sarin and Balakrishna Dattatreya Kumbhara and others, so many judgments.
Yes.
Our own High Court's 4 judgments, recent judgments, my lord.
And my Lord, may I again kindly express my apologies for that. Go for
It's
the
all
Lordship.
right. No problem. This happens.
I'm sorry.
Yes, fine.
Grateful, Lordship.
My lord, 117 and 118, I will file my objection. Let it be posted after vacation.
117. My learned had on 8th of January 2024 stated that he will file his objection. And it was directed to be listed in the week commencing 18th March. So now, my lords, we are in the month of May. And my learned friend is saying that he will file objection, let it come after vacation. How about the matter being taken up next year so that he will be dismissed from service and it becomes infructuous?
After vacation, I must file my objection.
Let there be stay.
I'll fix a.
118 is also the same. He's a doctor in 118. Then let there be stay in the interim, because in my case also we had
Stay of what?
Stay of conviction. Matlab, we have recent judgment of the Delhi High Court, matlab, Delhi Price case.
It needs hearing. Stay of conviction.
Matlab, in our case,
So easy.
matlab, I'll just take 5 minutes. 2 of their witnesses have supported me. Still then there's an order of conviction by the learned trial court. All the prosecution portions which are in favor of the accused are ignored from the judgment. It cannot be more lopsided than this. And what they are doing, my lords, is we are ready, including my friend, we are ready with the hearing. We want this stay. They are repeatedly taking time, my lords. Then they want our application to be infructuous. Then
The reverse is also sometimes correct. When the stay is taken, petitions are taking.
So far as my client
Anyway,
is concerned, he's a doctor.
Today, in any case, see, there is a in the bar there is some function.
My lords. My lord, all that I ask, my lord, let it be this side of the vacation. Otherwise, these people will lose their jobs.
After vacation, I must file my objection.
No,
I
then
order
let
my
them
file.
not precipitate for this.
I understand it. You take a chance on the last day of the meeting.
My lords.
Last day of the meeting.
I undertake to file the objection within the summer
Let them
vacation.
not precipitate matters then, my lord.
Sir, they are relying upon not Navjot Singh,
Dilip Rai,
now Dilip Rai.
I will cite so many decisions before your lordship. Your
I
lordship
know, I know.
Rest matter, my
They
lord.
have only one judgment, therefore he came with one judgment. You may be having more.
I am filing 15 decisions, my lord, in my favor.
My lord, we will rely on the impugned judgment, which has to take note of the materials before it.
Our own High Court have delivered judgment recently.
I'm sure if I'll hear the application for interim direction, I'll dispose of the appeal itself.
Yes,
my lord.
That's for
My lord,
sure.
that we are agreeable to that.
That's for sure. The amount of time we are going to
My lord.
spend on the application, it is better that
My lord, may hear
the
us.
main appeal
My
is
lord.
finished.
Now, my lord did hear my counsel, my colleague, saying that let this come chronologically. That means by the time these appeals are heard, we will be rotting somewhere. That is the objective of the vigilance department. It's very sad.
No, if you are insisting for an application,
we are agreeable.
Saying of conviction,
my lord,
it is better
my
that
lord, may
hear
hear
the
the
appeal and finish up. That is best way of.
My lord, we are grateful for that.
Instead of reading 5 judgments from your side, 5
Right,
judgments,
my lord.
better go into the evidence and finish up.
Yes. In this age of PCR and all these
get ready on merits.
My lord,
Forget about your application.
my lord,
Let us
we
go
are
ahead with
grateful.
the
We are grateful to that.
Get ready with the
Yes.
merits. I am not adjourning it
Only 6 witnesses
to
in
come
this
up
case.
on the regular course because they are insisting for stay of conviction.
Let
We
it
are
come
grateful.
after vacation, my lord, at least
No, no,
after
no.
vacation.
Then let us be in our jobs.
21st, let us.
Reopening
Idea.
day, your lordship.
Sir, idea of 21st is, I'll tell you from my side.
Yes.
Idea is 21st is, if it can be heard, I can reserve judgment during vacation, I can utilize the time.
We are great.
That's the idea.
Yes, my lord.
So please get ready so that we can see. If it can be done, it can be done.
Pardon, my lord. Last matter tomorrow, my lord.
Rest matter tomorrow.
My lord, 121. Only one correction, my lord. 121.
Yes, sir.
This will be listed next week, next Monday.
On 21st.
21st. Okay.
We will spend
So
little
I will
time, if possible, we will get judgment.
My lord,
I will
one.
argue on merit, I will argue on merit and I will cite the decisions, my lord.
Definitely. Welcome.
Oh,
Welcome.
Item 121, my lord. Only one correction, my lord. Only district is wrongly written, my lord. Well, I am giving this order, my lord.
121.
Instead of Kotak, my lord, it is Jagatsinghpur, my lord.
Kotak ଜାଗାରେ
Jagatsinghpur. हाँ, it is the जो
କଣ କଟକ ଲେଖିବା କଥା
Jagatsinghpur लिखिया था.
କଟକ ହେଇଯାଇଛି
आइए.
Item number 122, my lord. I'm on virtual mode.
Sir,
I pray let it come next after vacation because I have some tomorrow. From tomorrow I have to leave abroad, my lord. Therefore,
Let it be tomorrow because
not tomorrow. I am not available tomorrow.
Sir, there is an opposition by
There
your
is an
friend.
opposition. He is the petitioner. He has got the interim order, my lord.
Achha, you
He has
are
got the
angry.
interim order.
what's the wrong
Interim
with
order is in his
vacation
favor.
of tomorrow? I don't think there is any problem.
I can ask even if today, tomorrow, two
No,
times.
he wants that you enjoy the interim order.
He is enjoying the interim order, my
Matter
lord.
can be disposed of. I don't think.
I'm ready, my lord. I'm ready.
He's
I'm
saying
ready.
ready to
Today, if
approve
the
it.
lawsuit will take up, I'm ready now. Today, I'm ready to argue.
Yes, yes.
My lord, I have a one prayer, another prayer, my lord. 129, my lord. 129, the state has filed the counter, my lord.
Come tomorrow.
My lord.
The interim order be required to
Interim order to continue. Unless I say otherwise.
I may kindly pardon to mention, my lord, item 119 could not come up today. So this may kindly called on any day during this week. This may humble service.
He rolled over.
Obliged.
এটা delete so data করি